at the chat. I see that one team's code is team 10. Is the other one team 2?
Correct.
Okay. I thought so. Just wanted to check.
Great, thank you. Let me just close this box here real quick. So why don't we start off by
Judge
asking,
Klein?
Yeah.
Josh had to restart his computer, so I was asked if you can just hold on 1 second and he'll be joining the room shortly.
Great, thank you. Okay, why don't we give Josh a couple of moments to join us. Thanks everybody for your patience. I was just told that Mr. Landy was having some issues with his internet, so he should be logging in any moment now. So thank you for your patience.
Thank you, Judge.
Okay, and it looks like we have Mr. Landy here as well, so I think we're ready to pick things up. So thank you everybody for your patience as we worked out our technical issues here this morning. Let me ask, Mr. Landy, do you recognize any of the participants in this matter such that you would be biased in your scoring this morning?
I do not.
Okay, and now that Mr. Landy is on the screen, do any of the students recognize Mr. Landy? Okay, hearing or seeing no objection. So before I go into the rest of this, I'm going to ask a couple of things of each team member and participant here today. First, I asked once we get started with the actual trial, when you're not participating as a witness, as a examiner or a cross-examiner, if you can remember to keep your video muted, that will help with some of the bandwidth issues that we may have here this morning. I know this is something that I experience in my courtroom on a regular basis. So just something to keep in mind if we start getting some lag here, that could be part of the issue. Also, if you're not participating at the time, I would ask all folks to keep your microphones muted. That way there's no background noise or inadvertent comments that maybe you didn't realize you were saying out loud that get broadcast over the proceeding. Let's see. So why don't we start off by asking each side. I know that there were names and team numbers posted in the comments, but so that we could put a face to the name, I'm going to ask each side to introduce the participating team members, attorneys and witnesses. So you could just state your name and what role you'll be playing here this morning.
Good morning, Your Honor, members of the jury, and opposing counsel. My name is Ella Walters, and today I will be delivering the opening statements on behalf of the prosecution, conducting the direct examination of Kyle Cusack and the cross-examination of Professor Blake Van Allen.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Lily Radowski, and today I will be conducting the direct examination of Jordan Markowitz and the cross-examination of Taylor Perkins.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Jordan Ryan, and today I will be conducting the direct examination of Alex Cifuentes, the cross-examination of Avery Becker, as well as delivering closing arguments on behalf of the prosecution. At this time, may our witnesses introduce themselves.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Olivia Longi, and today I am Alex Cifuentes.
Morning, Your Honor, members of the opposing counsel, and members of the jury. My name is Braden Kerr, and today I am Kyle Cusack.
Good morning, Your Honor, opposing counsel, and members of the jury. My name is Charlotte Combe, and today I am Detective Jordan Markowitz.
Great.
And now for the defense, Your Honor.
Good morning, Your Honor, ladies and gentlemen of the jury and opposing counsel. My name is Haley Glass, and I'll be performing the cross of Detective Markowitz and the direct examination of Avery Becker.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Eliza Bachner, and I will be directing Taylor Perkins, crossing Alex Fuentes, and delivering the opening statement.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Sophie Liebman, and I will be performing the cross-examination of Kyle Cusack, the direct examination of Professor Van Owen, and the closing argument.
Your Honor, at this time, we ask that our witnesses be allowed to introduce themselves.
Yes, please.
Good morning, Your Honor, members of the jury, opposing counsel. My name is James Macera, and I am Blake Van Owen.
Good morning, Your Honor, members of the jury and opposing counsel. My name is Forrest Williams, and I am Taylor Perkins.
Good morning, Your Honor, members of the opposing counsel and jury. My name is Colin Blackford, and I am Avery Becker.
Okay, and just so you know, Mr. Blackford, your microphone was a little on the quieter side at first, so you may want to lean in to make sure that we're hearing you clearly in the courtroom. So great. Good morning, everybody, and welcome. So the next thing we need to do is we need to go ahead and swear in the team members, the gallery, the scoring panelists, and the witnesses. So what I'm going to do is ask members, normally if you were in the quorum, I would ask everybody to stand for the swearing in. And the purpose of the swearing in is to maintain a level of professionalism and uphold the code of ethical conduct during and after these mock trial proceedings. This applies not just to all of us as scoring panelists and presiding judge, but also to the participants as attorneys and witnesses and team members, all members of the gallery. And it's just to ensure that we have as faithful and experienced as possible for everybody participating. So starting first with team members, if you could please raise your right hand. Team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Okay, thank you. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Okay. And then gallery members who we can't see but are present on YouTube. This also includes teacher and attorney coaches, family members and friends. You could please raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round?
I do.
And then scoring panelists, if you could please raise your right hand. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
Thank you. So with that in mind, it is now 8:20. My understanding is that each team has their respective timekeepers in this matter, but whenever we are ready to begin, plaintiff's counsel, if you're ready to make your opening remarks.
Yes, Your Honor, but first we have a few preliminary matters.
Okay.
Your Honor, first we ask that the stipulations be constructively read into the record and published to the jury.
Okay. And does the defense have a position with regards to that request?
No objections to the request, Your Honor.
Okay. Ms. Ryan, did you want to read the stipulations into the record then?
Just constructively to have them considered read, but not actually have to spend time doing it today.
Understood. Then that will be deemed constructively read into the record and will be deemed a part of the record for the jury to consider.
Next, we ask that if any time the court cannot see or hear a witness or lawyer presenting, that the court intervene so that we may fix the problem. And if the problem persists for more than 15 to 20 seconds, the time stops until the problem has been fixed.
Okay, and obviously if there's any issues with audio and video, I'll address that as soon as I notice the problem. I would also ask the panelists if they're having, the scoring panelists, if they're having problems with hearing the attorneys and the witnesses also to speak up, because sometimes it's hard to tell whether it's a problem on our computer or a problem with the network as a whole. With regards to the 15 to 20 second, does the defense have any objection to that position?
No objections to that, Your Honor. I just ask that with any technical difficulties in general, rather than just if we can't hear or see, that the timing reflects that.
Okay, and I think what I'll ask is obviously for minor technical issues, we'll deal with them as they come along. If anything takes more than 15 or so seconds, we'll address that with the timekeeping. It's not appropriate for a student, for an attorney or witness to be penalized because of technical issues that prevent them from being heard. So we'll address those on a case-by-case basis, but we will strive to make sure that the time is kept as appropriate, as correctly as possible, not penalizing students, participants for their for technical issues, and not penalizing them with the score, not penalizing anybody with their scores because of any technical issues that we have here today.
Lastly, Your Honor, we just ask that we be allowed to screen share exhibits before they have been admitted into evidence for the purpose of identification by the witnesses.
Any objection from the defense on that?
No, Your Honor, I just ask that if they are going to share the exhibit on the screen, they must be using it for the purpose of entering the exhibit into evidence.
Okay, and I think that's a reasonable request. Typically in the courtroom, when we're not on Zoom or WebEx, the witness would have a chance to view the exhibit. So that will be permitted to screen share any exhibits. No need to ask the court for permission. You could just go ahead and do it. Obviously, if it's being done for something other than introduction or other proper use of the exhibit, then the opposing party can object at that time.
The prosecution has no further preliminary matters at this time, Your Honor.
Okay, thank you. Any preliminary matters for the defense?
Just kind of adding on to her last request, I ask that the jury members disregard any exhibits shared on the screen until they have been entered into evidence.
Okay, and typically if exhibits have not been introduced into evidence, they're not properly before the jury. So that will be also a standard operating procedure for the court in this matter.
Thank you, Your Honor. No further requests from the defense.
Okay, then is the plaintiff ready to begin with their opening statements?
Yes, Your Honor. If I may have a moment to get ready.
Sure, whenever you're ready. And let me just say, while folks are getting ready, if you were in the courtroom, you'd be in the physical courtroom, you'd be standing, which is typically how the court is addressed when you're asking questions or opening or closing. From my preference, whatever is more comfortable for you. If you prefer standing or sitting, I don't have a preference, just as long as we can hear you if you're standing away from your microphone. So Ms. Walters, whenever you're ready.
Thank you, Your Honor. He wanted revenge. He got it. On March 6th, 2020, Avery Becker was mad. After all, how could he not be? He had just been kicked off his school's mock trial team, a team that he had been a part of since freshman year, a team that he had poured his heart and soul and time into, all for it to be ripped away. He begged his coach, Mackenzie Brackman, to let him back on, but he ignored him. Heartbroken after his expulsion, he vowed to get back at his coach, even if it was the last thing he ever did. And on March 6th, 2020, Avery Becker got his chance. He came up with a plan to get even, a plan to vandalize Mr. Brackman's home. On March 6th, he went to Mr. Brackman's home to make him feel as frustrated and betrayed as he had felt. When he arrived, he beelined to the front door, but found it locked. Disappointed, he rounded the house to the back door when suddenly he saw none other than Coach Brackman himself, armed with a deadly knife. Realizing that he was running out of time and options, he frantically tried to disarm Mr. Brackman and eventually won, stabbing him in the back and fleeing as fast as he could. In today's case, the defendant Avery Becker has been charged with felony murder in the first degree and burglary in the second. As the prosecution, we hold the burden of proof, which means that we must prove to you beyond a reasonable doubt that the defendant unlawfully entered the Brackman residence with the intent of causing damage to his property, and while the defendant was there, Mr. Brackman was murdered. Now, ladies and gentlemen of the jury, we don't have to prove to you that Mr. Becker went to the Brackman residence with the intent of killing Mr. Brackman, but simply that it was the defendant Avery Becker who did. Now, ladies and gentlemen of the jury, we'll meet this burden by proving to you that it was Avery Becker who committed these crimes, that it was Avery Becker who killed Mackenzie Brackman. He wanted revenge. He got it. Today, ladies and gentlemen of the jury, you'll hear from Alex Cifuentes, a friend of the defendant, who will bring light to the rocky relationship between Mr. Brackman and Mr. Becker. She'll tell you about a series of text conversations that took place between herself and the defendant. And she'll tell you that in these text conversations, the defendant Avery Becker planned to break in and vandalize Mr. Brackman's home. Next, you'll hear from Kyle Kuzak, a crime scene reconstruction investigator who will tell you about physical evidence found at the scene. He'll tell you that this physical evidence proves his theory that this horrific tragedy was a break-in gone wrong. Finally, ladies and gentlemen of the jury, you'll hear from Detective Jordan Markowitz about the defendant's cell phone records. She'll tell you that these records show that the defendant's phone connected to the cell tower nearest the Brackman residence not once, not twice, but 3 separate times. That the defendant's phone connected to the cell tower that it should never have connected to 3 separate times. And she'll tell you that these cell phone records show that the defendant was at the Brackman residence at the time of the murder. He wanted revenge. He got it. At the end of today's trial, my co-counsel Jordan Ryan will stand before you and tell you that Avery Becker wanted revenge. And ladies and gentlemen of the jury, you'll see that he got it. She will ask you to find the defendant guilty. Thank you.
Thank you, Ms. Walters. Whenever defense is ready for their opening statements.
Your Honor, may I proceed?
Yes, please.
May it please the court. Good morning, Your Honor, members of the jury. I am here today on behalf of my client, Mr. Avery Becker, who has been wrongfully accused of murder in the first degree and second-degree burglary. Today, the evidence will show this man is not guilty of the charges filed against him. You will see that the case presented by the prosecution is simplistic, speculative, superficial. You will see today that the case presented by the prosecution is 1, simplistic. You will hear Detective Markowitz testify that the first and only suspect was concluded to be the murderer without further investigation or conclusory evidence. This makes their case 2, superficial. The police performed a superficial investigation and barely skimmed the surface of the available and relevant evidence. The prosecution's investigation started with an interview of one of the victim's students. Listen to this student, Alex Cifuentes, who provided the police with the suspect. However, this student was jealous of Avery Becker and had motive to cause trouble for him. Prosecution then decided to name Mr. Becker the culprit. You will hear that the police did not further investigate and question other students, teachers, people in Mr. Brackman's life, or neighbors who may have witnessed the murder. Detective Markowitz will also tell you that the police did not investigate other suspects, including Blair Rollins, who had a substantial grudge against Mr. Brackman, who is the same build as Avery Becker, was missing from school the day of the murder, was friends with the student who was using Avery Becker's phone the night it went missing, and finally, coincidentally vanished from Colorado after the murder of Mr. Brackman. You will also hear of cell data evidence recovered from cell towers. However, listen carefully for evidence from the day before and days following the murder to determine the user and location of this phone. The prosecution's case has evidence that is 3, speculative. The prosecution's burden is beyond a reasonable doubt, the heaviest of burdens. Avery Becker's phone, a crucial factor in this case, went missing the night before the murder. It is unknown who had it the night before, day of, the days following the murder, and to this day, it is still missing. You will hear about the text purportedly sent between Avery Becker and Alex Cifuentes, but notice that Alex Cifuentes' phone is never produced. In fact, the police never investigated that phone, nor even saw the text to prove their authenticity. You will also hear about the the crime scene reconstruction created by Mr. Kyle Kuzak. But listen that this detailed analysis does not decisively implicate a specific culprit. In fact, the video from the Ring doorbell recovered shows that it is instead impossible to tell who the intruder is. For the defense, you will hear from Mr. Avery Becker, who has been wrongfully charged with murder in the 1st degree and 2nd degree burglary. He will tell you that he and Mr. Brackman had a contentious relationship, yet it was a far cry from murder. Second, you will hear from Mr. Taylor Perkins, who will provide an alibi for Mr. Becker for the entirety of the day of the murder. And finally, Blake Van Owens, a private investigator in cases across the country, in expert cases in crime scene reconstruction, cell tower analysis, and police practices. He will debunk the police's theory with solid evidence and no ulterior motive. The definitive facts of this case are that on March 6th, 2020, someone broke into Mackenzie Brackman's house. And at that time, when that person was in the house, Mackenzie Brackman was stabbed with a knife and he died. It is a tragedy, yet one that my client had none to do with. The prosecution has a simple case, superficial investigation, speculative evidence. The prosecution cannot prove that Avery Becker committed these crimes. So I ask that you find the defendant not guilty of the charges filed against him. Thank you.
Great. Thank you, Ms. Bachner. We're now ready for the evidentiary portion of this case. The way this will work is the prosecution will have an opportunity to call their witnesses. Once they rest their case, the defense will have an opportunity to call their witnesses. Typically, the way this works is the attorney calling the witness will conduct their direct examination. Then the other side will have an opportunity for cross-examination. The initial party calling the witness will have an opportunity for redirect, which is optional and only at the request of the court. And then recross may occur if there's a redirect, and the redirect and recross are limited to the scope of the previous testimony. We'll go through all the witnesses, and then each side will have an opportunity to make their closing remarks. Whenever the prosecution is ready to call their first witness.
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
Okay, Mr. Cifuentes?
Miss Cifuentes,
Ms.
sir.
Cifuentes, thank you. I apologize for that. Ms. Cifuentes, you have been put under oath, so whenever the people are ready with their questions.
Please introduce yourself to the jury.
Good morning, y'all. My name is Alexandria Cifuentes.
tell us a little bit about yourself, Ms. Cifuentes.
Well, I recently took a physical journey here from Fort Worth, Texas. I moved. And along with that, I've been taking a spiritual journey to help heal my soul and embrace my true nature.
So are you a student, Ms. Cifuentes?
I sure am. And I enjoy doing things like mock trial. I do tarot reading, palm reading from time to time.
Where do you participate in mock trial?
At CHS, also known as Colorado High School.
And how do you know the defendant, Avery Becker?
Well, Avery? Oh, she was the one who introduced me to mock trial.
And before we get any further, could you explain what exactly is mock trial?
Mock trial is this fun little thing. It's kind of like a play, but instead of putting on a play, we, the high school students, put on a court case and play lawyers and witnesses. I adore it.
Does it take a lot of time to prepare for mock trial?
It sure does. We ain't CHS for nothing.
And who coached yourself and Avery Becker at mock trial?
Mr. B, Coach Brackman. Man, he was just the nicest Aries I ever met. Kindest soul. I'll miss him.
And did people on your team get along with Coach Brackman?
They did. He was real well liked, for the most part.
What do you mean, for the most part?
Well, Avery Becker, she had a little tendency to show up late, not be prepared, and that caused tension between the team and Coach B. And oh my Lord, regionals was almost a disaster.
Why was regionals almost a disaster?
Well, Avery had been doing her little thing of showing up late, being unprepared, so Mr. B demoted her to the B team. And she somehow wormed her way back to the A team. I don't really know, but it was a fiasco.
Well, even after that whole fiasco, did your team do well at regionals?
Of course we did. We qualified for state, and Avery even won a couple awards.
What did you have to do after qualifying for state?
We needed to practice real hard. We were actually at practice a couple days after the competition when something happened.
Ms. Cifuentes, what happened?
Avery and Mr. B got into an argument. I mean, I can't blame them. Mr. B was an Aries and Avery is a Taurus, so it was bound to happen. They were arguing over Avery's awards.
What did the defendant do as a result of that argument?
Avery stormed out of the classroom. Mr. B followed him, but I don't really know what happened after that. I do know that Avery was permanently kicked off the mock trial team, though.
Well, even after the defendant permanently was kicked off that team, did the two of you stay in contact?
We sure did. I'm a Libra. I ain't gonna abandon my friends like that. Avery texted me.
Would you recognize pictures of those texts if I were to show them to you?
Yes, ma'am.
Your Honor, I ask that my co-counsel start sharing Exhibit 14.
Yes, please.
Ms. Cifuentes, what are these?
Those are the texts between myself and Avery.
And have those texts been altered or changed in any way since they were first sent or since you last saw them?
They have not.
Are they fair and accurate representations of the text you received?
Yes.
And to be clear, who sent you these texts?
Avery did. Avery Becker.
Your Honor, at this time, we ask that Exhibit 14 be admitted into evidence.
Any objection?
Yes, Your Honor. Objection to hearsay, Rule 801, and also to authenticity, Rule 901.
Okay, any response from the prosecution?
Yes, Your Honor. As to the authenticity, under Rule 104, we have to prove with a preponderance of the evidence that these 10 texts were authentic and sent by Avery Becker. We have done this as this witness has just testified that it was Avery Becker who sent her these texts, that they have not been changed, and that this was a form of communication that the two of them used. As to the hearsay, the texts by Avery Becker fall under Rule 801D2, a statement of a party opponent, and the texts from Ms. Cifuentes are not being used for the truth of the matter asserted, but for the effect on the listener, Avery Becker.
Okay, Ms. Bachner, any response to that?
I still stand by my objection.
Okay, thank you. So with regards to the authenticity objection, the purpose of authenticity is that the documents are what they purport to be and that the witness has a basis to testify as to what the documents are. So the court will overrule the objection on authenticity grounds. And then with regards to hearsay, the court finds that this exhibit would meet the exception to hearsay as described by the people, and therefore Exhibit 14 will be admitted into evidence.
Ms. Cifuentes, what did the defendant originally text you about?
Avery texted me about getting back on the mock trial team.
Did you try to help her with that?
Of course I did. I gotta show Avery that Southern hospitality.
If my co-counsel could stop screen sharing, please. Were you successful with this?
I was not, I talked to Mr. B. I did everything. I prayed to my crystals, but it ain't happening for Avery.
Did you tell the defendant that they weren't going to be let back on the team?
I did. And Avery's response, it worried me.
Why did his response worry you?
Well, Avery texted me and said, if he's still upset about his car, then just wait until he sees what I do to his house.
How did you respond to it?
Yes, is there an objection?
The evidence of the text were entered not for the truth of the matter asserted, yet now it is being used for the truth of the matter asserted.
Okay, Ms. Ryan?
If I may respond, Your Honor, I'm asking this witness what she said to the defendant, what her response was. You will see that her response was asking the defendant what they were going to do. Questions do not inherently assert any truth, and this does go to the effect on the listener in that it was the Avery Becker's response.
Ms. Bachner, any follow-up to that?
Well, just what Avery said in these texts is being offered for the truth of the case to prove his guilt, even though the texts were admitted for not that purpose.
Well, just to clarify, the texts were admitted also as being a statement of a party opponent, and so the objection is going to be overruled.
Ms. Cifuentes, how did you respond to what the defendant said?
I asked Avery what he was gonna do.
And what did the defendant tell you?
Avery said, I'm gonna wait until he's at work, then break in and trash it.
Thank you, Your Honor. No further questions.
Okay, cross-examination.
Good morning, Mr. Fuentes.
Good morning.
So let's get straight into this. At the Fry Shack on March 5th, you touched Avery's phone, isn't that right?
I saw Avery at the Fry Shack.
So you didn't play games on his phone at all?
Yeah, I did play.
And the next day, Avery's phone went missing, isn't that right?
I believe so, yes, ma'am.
Moving forward, you simply sent screenshots of the text to the police, isn't that right?
Well, I offered to bring in my phone. I did. The police
but you just
said
sent
they
a
didn't
screenshot.
need it.
So you just sent a
Yes,
screenshot.
I did.
May I
I'm sorry,
please
I
view
can't hear you.
Exhibit 14?
Yes, please, if the Exhibit 14 could be placed back up on the screen. Thank you.
When you receive a text message, a date and time are shown. Isn't that right?
Well, I believe so, but I ain't an expert on text.
And on this text, do you see a date and a time sent?
No, ma'am.
Okay. And that would mean that the police would have to speculate if these texts were authentic. Isn't that right?
Objection, Your Honor.
On what grounds?
This lawyer has just asked my witness to speculate as to whether the police would or would not need more than a screenshot to authenticate this. This witness is not an expert in police investigation or authenticating documents. She would not be able to testify to that.
Ms. Bachner?
This witness sent in evidence, and it would have to be easily read in order for the police to be able to use it. So it just goes to the credibility of the witness.
Any response, Ms. Ryan?
Your Honor, I believe the question was as to whether the police could authenticate the document through just a screenshot, and that's not under this witness's personal knowledge or experience. This witness has testified that Avery Becker sent her these texts, that they are authentic, but not that she has an experience in authenticating documents.
Under the rules of evidence, a lay witness can testify regarding items within their experience in their day-to-day lives. And so the court will allow the testimony regarding the witness's perception. That said, the jury will be advised at the end to not consider the testimony of this witness, Ms. Cifuentes, as expert testimony on the subject. So the objection is overruled.
Moving forward, you replaced your phone that contained the crucial evidence for this case, didn't you?
It was losing battery, so I ain't gonna keep a phone that doesn't work. Yes, I did replace it.
Moving forward, you were jealous of Avery's success on the mock trial team. Isn't that right?
Avery did have a lot of success on the mock trial team, and I didn't necessarily agree with it.
You said it felt like a slap to the face every time he succeeded and you didn't. Isn't that right?
That is correct, but that's just how mock trial works.
You spent hours preparing for mock trial. Isn't that right?
I did.
You were one of the hardest
dedicated.
working students on that team. Isn't that right?
I worked hard.
Yet Avery got all the awards in all the tournaments. Isn't that right?
I will admit, Avery was quite good at mock trial.
And he was constantly picked over you by Coach Brackman. Isn't that right?
Avery had a certain way with words when it came to participating in this event.
Moving forward, do you know Blair Rollins?
I believe so.
And who was the lawyer on the case of Blair Rollins' father going to prison?
If I remember correctly, it would have been Mr. Bay, I think. He was always doing nice things to help us out. He really did.
And do you know what
care.
the outcome of this case was?
I believe that Blair's father went to prison.
Objection, Your Honor.
On what grounds?
Lack of personal knowledge. This witness was not present for that trial and does not have the personal knowledge to talk about a trial that involved Mr. Rollins and Mackenzie Brackman if she was not there for it.
May I respond, Your Honor?
Yes, please, Ms. Bachner.
This case actually was common knowledge, as it was a student whose father was sent to prison. And the lawyer on this case that lost this case was Coach B, who happened to be very close with Alex Cifuentes, and was also the coach of the mock trial team. So everybody on this team, and basically in the entire school, would have known about this case.
Your Honor,
Ms. Ryan, any reply?
Yes, Your Honor, any of that foundation would have been based on hearsay. Common knowledge is not grounds for just personal knowledge. This witness wasn't present for the trial. The only way she could have known about it would have been through hearsay.
Did Ms. Cifuentes testify as to how she knew about the outcome of the trial?
She did not, Your Honor.
Okay, I think Ms. Bachner can lay foundation as to how Ms. Cifuentes knew about the trial, so the objection sustained, but with the opportunity to re-ask the questions with a little bit of foundation.
Yes, Your Honor. So did you know that Blair Rollins' father went to prison?
I believe I do know that.
Objection, Your Honor. This was the same question that we just had asked. This has not laid the foundation for how this witness would know that.
I think, Ms. Bachner, I think it might make sense to ask some questions regarding how she has the knowledge of these events.
I will just move forward if that's okay.
Okay, thank you. The objection
And
sustained.
have you seen Blair since the murder of Mr. Brackman?
Well, no, I haven't, but Blair and I ain't close friends.
No further questions.
Okay, thank you. Are the people requesting any redirect?
No redirect, Your Honor.
Okay, thank you, Ms. Cifuentes, for your testimony this morning. Whenever the people are ready with their next witness.
Yes, Your Honor. At this time, the prosecution calls Kyle Cusack to the stand.
Mr. Cusack, if you could turn your video on, please.
Where's the button? Oh, here it is.
There we go.
Okay. Yeah. So sorry, my grandchildren were using this right before I got on here.
Thank you, Mr. Cusack. As a reminder, you were sworn in and placed under oath at the start of this proceeding, so whenever the people are ready.
Good morning. Could you please introduce yourself to the jury?
Good afternoon, everybody. My name is Kyle Cusack.
What do you do for a living?
I'm a crime scene reconstructor.
Could you briefly describe what crime scene reconstruction is?
It's basically the process of taking all of the evidence from a particular case and using it to reconstruct a plausible scenario for what could have happened.
What experience do you have?
I've done this for the past 19 years. I'm actually only 3 days away from retirement.
Congratulations, Mr. Cusack. Do you specialize in anything?
I specialize in complex crimes like homicide, burglary, and home invasion.
Were you certified for your position?
I got certified by the Colorado Bureau of Investigation.
How are you involved in today's case?
I'm the chief crime scene reconstructor for the police.
What facts or evidence did you rely on to come to your conclusion?
I reviewed all of the witness statements in this case. I reviewed all of the exhibits, and I actually got the chance to visit the crime scene.
Were these facts and evidence sufficient?
They were, yes.
What methods did you use?
I used the standard 5-step reconstruction process.
Were these methods reliable?
Very. They're used by almost every crime scene reconstructor.
At this time, the prosecution wishes to tender Mr. Cusack as an expert in crime scene reconstruction.
Okay, any objection or request to voir dire this witness?
No objection or voir dire at this time, Your Honor.
Okay, so the court will accept Mr. Cusack as an expert in crime scene reconstruction. Whenever you're ready, Ms. Walters.
Thank you, Your Honor. Now, let's briefly talk about your investigation. Did you visit the crime scene?
I did, yes.
Do you know if the police visited the crime scene?
Yes, I'm pretty sure they did.
What did they find?
Well, they found a dead body laying on the ground.
Did they find a murder weapon?
They did.
What was this murder weapon?
It was a bloody chef's knife laying on the ground.
Where was it found?
It was found right next to the body.
Would you recognize both the picture of the body and the knife if I showed them to you?
Probably.
Your Honor, if my co-counsel may begin screen sharing Exhibit 4 and 5.
Okay, whenever co-counsel is ready to share those exhibits.
Mr. Cusack, do you recognize Exhibit 4?
Yes, I do.
Exhibit 5?
Yeah, I recognize that as well.
Do they appear to have been altered in any way?
I don't believe so, no.
Are these fair and accurate depictions of the exhibits?
Yes.
At this time, the prosecution wishes to enter both Exhibit 4 and 5 into evidence.
Any objection?
Yes, I object on the grounds that this is more prejudicial than probative.
Your Honor, if I may respond, under
Yes,
Rule
please.
Under Rule 403, the evidence must be substantially more prejudicial than probative, and this evidence is not, because this evidence simply depicts the crime scene and in no way links the defendant to the crime scene, therefore making it not more prejudicial than probative.
Ms. Liebman?
I was actually referring to the copious amounts of blood in this picture. I'm sure that the jury does not want to see all this gore, and it just goes to bias the jury against the defendant because looking at all this gore, it's very shocking. Additionally, there is another picture of the knife that fully demonstrates anything that the prosecution would need to show about the knife without the additional gore.
Your, if I may respond, again, both Exhibit 4 and 5 in no way link the defendant to the crime and are just simply showing what happened at the crime scene and what caused the cause of the murder.
Did Mr. Kuzak testify that the knife is as it was found at the crime scene?
Yes, Your Honor.
Okay, so based upon the rules of evidence, evidence that is admissible can't be so prejudicial as to substantially outweigh its probative value. Here, there's an inherent prejudicial nature of any exhibits that are presented, but the court finds that the prejudicial value does not substantially outweigh the probative value of these exhibits, particularly as it relates to the defendant in this case, and therefore the objection is overruled and exhibits 4 and 5 will be admitted into evidence.
Mr. Kuzak, were you able to determine where the knife came from?
I was, yes.
How?
There was an open knife drawer in Mr. Brackman's kitchen, as well as a large kitchen knife missing from his knife set on the counter.
Why was this significant?
Well, it showed that the perpetrator hadn't actually brought a knife with them. Rather, it came from the Brackman's kitchen.
If my co-counsel could end screen sharing. Now, Mr. Kuzak, are you aware of the cause of death?
I am, yes.
What was it?
It was a stabbing and bleeding out.
What other evidence was found at the crime scene?
Well, there were also a set of scuff marks found near the back door, as well as a broken plate found in the kitchen.
Why was this significant?
It was significant because it also indicated that there was some kind of struggle that happened at the crime scene.
Do you know if Coach Brackman's home had a security system?
Yes, I do.
What was that security system?
He had one of those newfangled Ring security systems. It hooks right to your phone. I don't really know how it works, but it's pretty interesting.
Were you or your team able to obtain video from these ring doorbells?
Yes, we were.
Have you viewed these videos?
I have, yes.
What do they depict?
They depict an intruder walking up to the front door, going around through the back gate, going in through the back door, and finally running out through the front door.
Do you know if these exhibits have been identified here in court as exhibits?
I believe the most relevant one is probably Exhibit 12.
Did they appear to have been altered in any way?
No.
Your Honor, if at this time the prosecution wishes to admit Exhibit 12 into evidence.
Any objection?
Objection, Your Honor.
Okay, Exhibit 12 will be admitted into evidence.
Your Honor, if my co-counsel may begin screen sharing what has just been admitted as Exhibit 12.
Yes, please.
Mr. Kuzak, what does Exhibit 12 depict?
Exhibit 12, from what I could see, depicted some perpetrator entering through the back door of the Brackman residence.
Were you able to reach any conclusions about what happened inside the house?
I was, yes.
What were those conclusions?
So the first thing that happened is the perpetrator entered through the back door. And then Mr. Brackman was notified somehow, either through the security system or maybe just seeing an armed intruder or an intruder coming into his house. He then went to get some kind of weapon to defend himself. And from there, some fight or struggle ensued, which the perpetrator ended up winning, grabbing the knife from Mr. Brackman and stabbing him in the back.
Finally, Mr. Cusack, what conclusions did the evidence at the scene lead you to?
Don't take away anything else. There are two things. First is that this crime was a burglary gone wrong. Second is that Mr. Brackman was stabbed after some kind of struggle.
Thank you. No further questions.
Thank you. Cross-examination.
Good morning, Mr. Cusack.
Good morning.
In your investigation, is it correct that you reviewed all the photos and videos pertaining to this case?
I reviewed all of the exhibits.
You also mentioned that among these photos that you reviewed were photos depicting blood droplets and blood spatters. Is that true?
Yes.
And is it also true that the reason the court cannot examine these photographs today is because they were lost?
They weren't lost. They were corrupted.
In your investigation, you would have also reviewed the photos of the scuff marks. Is that correct?
Yes.
Now, is it true that your theory is that these scuff marks indicate a struggle?
Yes.
But isn't it also possible that these scuff marks being right next to the victim's back door could have been caused by any number of things? Isn't that also true?
That is true, yes. But it is very, these indicate to me that this was some kind of struggle happening.
All I asked was that if it was possible, Mr. Cusack. So next in your theory, is it correct that you believe the victim grabbed a knife from the knife block to defend himself?
Yes.
And according to your theory, it is true that the same knife would have then been used to stab the victim in the scapula after a brief scuffle?
Yes.
But isn't it also true that the knife recovered from right next to the body, the one covered in blood, was a completely different brand of knife from the knives in the block?
Yes, I believe it was a Chicago cutlery brand.
So in your investigation, you believe that the victim and intruder engaged in a struggle, is that correct?
Yes.
And that during the struggle, the intruder gained control of the knife and stabbed the victim, is that also true?
Yes, that's what the scuff marks and the broken plate show.
And according to the coroner's report, the victim was stabbed in the scapula, is that true?
Yes.
Objection, hearsay.
Sorry, I didn't hear the objection with us. You said objection hearsay?
Yeah.
Okay, Ms. Liebman?
Could opposing counsel please explain their reason for that?
Yes. First of all, the coroner's report has not been admitted into evidence. And additionally, it is an out-of-court statement, and I believe what you're talking about in the coroner's report is that the cause of death was like a stabbing to the scapula, and that is being used for the truth of the matter, and it is an out-of-court statement.
Ms. Liebman?
Let me just rephrase my question, if that's okay, Your Honor.
Okay, the objection sustained with leave to rephrase the question.
According to the evidence that you found at the scene and the stab wound on the body, isn't it true that the victim was stabbed in the scapula?
I mean, I'm not really a medical examiner myself. I'm not really sure.
I'm asking about the evidence that you saw at the scene. Isn't it quite obvious that the victim was stabbed in the shoulder?
The victim was stabbed in the shoulder, yes.
That is all I'm asking. So is it then true that to do what you're describing, the intruder would have been unnaturally tall to reach around a grown man and stab him in the shoulder?
I've been in my share of scuffles. I know that sometimes the little ones are the most scrappy.
I'm not talking about strength here. I'm talking about height. We're talking about a teenager. Isn't it unlikely? Is it true that it's unlikely that a teenager would be able to reach around a grown man and reach up to his scapula and stab him? Isn't that unlikely?
I don't think it's very unlikely at all. It is completely possible that a young athletic teenager could have overpowered, what is this guy, 50? He could have overpowered someone like that.
let's talk more about the ring videos. Is it correct that the intruder is wearing a mask in these videos?
Yes, it is.
And isn't it also true that the intruder is wearing gloves and a hoodie?
They are, yes.
So it would be basically impossible to tell a person's race, gender, or any other defining characteristic from these videos. Isn't that true?
I mean, you can sort of tell their general height and build from this, and it does match the defendant.
Are
But
they a defining characteristic? That is what I asked about.
I mean, height and build is a defining characteristic.
Isn't it also true that there was no physical concrete evidence to actually link anybody, including the defendant, to the scene of the crime? Is that correct?
I don't necessarily know what you mean by physical evidence. There was no DNA or fingerprints, but
yes.
I'm sorry, could you repeat your question? My hearing isn't what it used to be.
I was just clarifying that I meant things like DNA and fingerprints, and I was repeating my question to clarify that there was none of this physical evidence.
I mean, I don't necessarily know what your definition of physical evidence is, but there wasn't any DNA or fingerprints discovered, no.
Now, according to your theory, the victim would have been alerted to the presence of the intruder via the Ring app. Is that also true?
It's possible that that's what happened. It's also possible they just saw some kind of person sneaking around their house.
We're just specifically talking about the Ring app alerts. In your investigation,
that is definitely a possibility.
In your investigation, however, you failed to actually get records to confirm the alerts. Is that correct?
No, we weren't able to get those records.
So is it then possible that the victim could have failed to receive these alerts by any number of ways?
It's possible, but I mean,
That's
it's
all I
kind of
asked
hard
you
to
to
miss
do.
someone sneaking around your house.
I was just talking about the Ring alerts. Moving on. In your testimony, you said that you wished you had more evidence. Is that correct?
Yeah, but that's true of any crime scene. You always wish you had a few more fingerprints, a few more strands of hair. It's never 100% with these kinds of things.
Mr. Cusack, how can we possibly take what you're saying as proving the defendant guilty beyond a reasonable doubt if you don't have enough evidence?
I mean, there's plenty of other evidence, and I think Miss Markowitz will come up and talk about a bit more of it. But my theory still stands, and it does implicate the defendant.
Isn't it correct that you could be sending a teenager to jail over not enough evidence then?
No, I believe there is plenty of evidence in today's case to send Miss Becker to jail.
But
committed murder.
Objection argumentative for the last question.
Ms. Liebman?
I would like the co-counsel to explain, or the opposing counsel to please explain their objection.
Yes, you phrased it, isn't it possible you're sending an innocent teenager to jail? That is argumentative. That's like an argumentative question.
Ms. Liebman?
That's just simply stating the stakes in this case, which everybody knows.
I guess what I would say is the question is a bit on the argumentative side and doesn't necessarily get to the evidentiary foundations that we need to prove here today. So the objection on that question is going to be sustained.
No further questions, Your Honor.
Thank you. Are the people asking for any redirect?
Yes, Your Honor. Mr. Cusack, you were asked about your theory on cross. Would you like to explain that a little bit more?
I mean, of course. What happened was some intruder entered the house. Mr. Brackman got a knife.
But generally speaking, witnesses allowed to clarify their answer even if the question has previously been asked. And so the objection will be overruled, and you will have a chance, Ms. Liebman, to cross-examine on that subject as well, recross.
I didn't hear the objection. I'm just keeping track. What was it?
Asked and answered.
Thank you.
Would you like me to re-ask the question, Mr. Cusack?
Yeah, I'm old. I have a bad memory.
You were asked on cross about your investigation. Would you like, or your theory, would you like to explain that a little bit more?
Oh, yeah, of course. What happened was an intruder entered through the back door. Mr. Brackman was either notified there or at some point went to get a knife to defend himself. Then a struggle or a fight ensued where Mr. Brackman was disarmed and was then stabbed.
Finally, did you have enough evidence to come to your conclusion?
Yes.
Thank you. No further questions.
Thank you. Ms. Liebman, recross limited to the scope of redirect.
No recross at this time.
Okay, thank you, Mr. Cusack, for your testimony today. Are the people ready with their next witness?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand.
Okay, Detective Markowitz. Just a reminder, Detective Markowitz, that you have been previously placed under oath in this matter. And so whenever the people are ready to begin with their examination.
Good morning. Would you please introduce yourself to the court?
Good morning. My name is Jordan Markowitz, and I'm a detective with the Denver Police Department.
How are you involved in today's case?
Ma'am, I was one of the investigators regarding the murder of Mackenzie Brackman.
How long have you worked in law enforcement, Detective?
Well, I've been with the DPD for around 10 years now. I've been a detective for the past 7.
Do you have any specialized training?
Yes, ma'am. The majority of my specialized training is in regards to cell phones. I have a certification in cell phone technology and forensic data recovery from the American Academy of Law Enforcement.
What did this certification entail?
Well, ma'am, I had to pass a 3-day certification course as well as a certification test. And through this, I now have extensive knowledge on cell phone data recovery as well as call detail record analysis.
Have you had a chance to use your knowledge in your work before?
I have, ma'am. I've downloaded the contents of hundreds of phones at this point, and I've also used CDR analysis in over 50 cases.
Did you have a chance to use your knowledge in today's case?
Yes, ma'am, I did.
At this time, the prosecution moves to admit Jordan Markowitz as an expert in cell phone technology and cell data recovery.
Okay, any objection or request for voir dire?
I have a brief voir dire, Your Honor, if that's all right.
Okay, Ms. Glass, whenever you're ready.
Detective Markowitz, is it true that you only had 3 days of training in order to get your certification on cell phone technology?
With the American Academy of Law Enforcement, that's how they do it, ma'am. So that's a yes to your question.
Thank you. Moving forward, it's also true that cell phone analysis is not an exact science, or in other words, you can't always be certain that your analysis is true. Is that also correct?
I would say that's not correct, ma'am.
So do you know for absolute certainty which tower each cell phone is going to connect to at each time?
Well, ma'am, call detail record analysis isn't like a GPS. It requires that looking at patterns between multiple cell towers and looking at which antenna on each tower they connect to. So it's not like a GPS, if that's what you're asking.
The algorithm used for cell phones to pair with a tower is an extremely complicated one. Is that true?
It's a complicated algorithm, but when you look at the call detail records, you got to work and analyze the patterns. And that's what
And it is
I've
also
trained to do.
true that you cannot be absolutely certain that a cell phone will pair with the closest tower. Is that also correct?
Ma'am, this is a rare occurrence. However, if a cell tower is busy, a cell phone will connect to one that is further away.
Your Honor, at this time, I object to Detective Markowitz being entered as an expert in the field of cell phone technology due to her limited 3-day training in the field and the fact that cell phone analysis is not precise enough to be able to draw conclusions that she may attempt to draw with the title of an expert.
Okay, Ms. Rudowski.
Your Honor, under Rule 702, you may be qualified as an expert by knowledge, skill, experience, training, or education. Detective Markowitz has just testified that she has worked in law enforcement for 13 years. She has a certification in cell phone technology, and she has downloaded the information off of hundreds of cell phones. Furthermore, as to the conclusions that she will draw, opposing counsel is welcome to cross-examine her on those, and this goes to the weight of her testimony and not the admissibility of her as an expert.
Thank you. Any response, Ms. Glass?
Yes, Your Honor, a brief one. I wasn't calling into question anything to do with her experience in the police field. If opposing counsel would like to enter them as an expert within that field, I have no issues with that. However, when it comes to cell phone technology, all that or Detective Markowitz has is this 3-day training experience, which I don't believe is substantial enough to enter her in as an expert.
Okay, and so typically in a case like this, under Rule 702, the amount of training that one needs to be qualified as an expert is not specifically spelled out. The court finds that the objection goes to the weight that the jury might give to the evidence and not to the admissibility of the evidence. And so Ms. Glass and the defense will have an opportunity to thoroughly cross-examine Detective Markowitz after direct examination. So the court will accept the tender of Detective Markowitz as an expert in this area.
Now, Detective, you mentioned that you had a chance to use your knowledge on cell phones in today's case. How were you able to do this?
Oh, well, ma'am, I obtained a warrant to look at the call detail records, as well as cell phone of Avery Becker, who is my primary suspect.
What did you obtain from this warrant?
Well, as I said earlier, I got the call detail records from the defendant's cell service provider. The warrant also allowed me access to Mr. Becker's phone. However, his attorneys told me he had lost it, so I was not able to access it.
How did the call detail records that you did receive work?
Well, ma'am, call detail records or CDRs work by, I guess a good way to explain it is anytime someone receives a text or a call, a record of the interaction is created. And this record can tell us things like the time the interaction took place, the number of other phones involved in the interaction, and most importantly, the cell tower with which the cell phone communicated and connected with in that interaction.
Why is the cell tower that the phone connected with important?
Well, ma'am, this can tell us the general area a phone is located in. Furthermore, at the top of each cell tower, there are 3 antennas that each cover a 120-degree arc. Based off an antenna that a cell phone connects with, we can also tell what direction it comes from. So CDR analysis can tell us the general area and the direction phones come from.
Did you find anything from the defendant's cell phone records?
Yes, ma'am. I actually made a diagram of my findings.
Would you recognize this diagram if you saw it?
I would, ma'am.
Your Honor, permission for my witness to screen share Exhibit 15 constructively outside the eyes of the jury?
Yes, please.
Detective, what is this document?
Ma'am, this is a diagram I made based off the call detail records I obtained from Mr. Becker's cell service provider.
Is it a fair and accurate copy of the diagram that you made?
It is, ma'am.
Has it been altered or changed in any way since you last saw it?
It is not.
At this time, the prosecution moves to admit Exhibit 15 into evidence.
Any objection?
No objections, Your Honor.
Okay, Exhibit 15 will be admitted into evidence.
Could you explain for me what these records showed?
Yes, ma'am. So the defendant's CDR showed she had 5 different connections made to 3 different cell towers the day of the murder. These are the 3 cell towers her phone connected to.
Can you describe the connection with the first cell tower for the jury?
Yes, ma'am. So the first cell tower is at the top of the exhibit. I'm going to be circling it in red right now. And we found that Ms. Becker's phone connected to this cell tower at 12:47 p.m. the day of the murder. This cell tower also covers Ms. Becker's own residence, which I'm stamping with an X mark right now.
Can you describe the connection with the second cell tower?
Yes, ma'am. The connection with the second cell tower is this middle one right here, which I am circling in red again. So this cell tower covers Rock Creek Parkway, which is the most logical distance from Avery Becker's home to Mr. Brackman's home. I'm going to stamp a place on Rock Creek Parkway right now. And we found that Ms. Becker's phone connected to this middle cell tower at 12:55 p.m. the day of the murder.
Can you describe the connection with the third cell tower?
Yes, ma'am. The connection with the third cell tower happened down here at this bottommost cell tower I am partially being able to circle right now. This cell tower covers Mr. Brackman's residence, which is right here. And we found that Ms. Becker's phone connected to this cell tower 3 separate times. One at 1:05 p.m., another at 1:06 p.m., and lastly, 1:17 p.m. the day of the murder.
Can you point out where the mall is on the map?
Yes, ma'am. I'm going to stamp them all with a green check mark. It's slightly above and to the right of this middlemost cell tower.
Can you point out where the fry shack is on the map?
Yes, ma'am. The fry shack, which I'm also going to be stamping with that check mark, is below and slightly to the right of this middle cell tower.
Now, just to clarify, do either of these locations align with any of the directions of the relevant cell towers?
No, ma'am. As I mentioned earlier, each cell tower has 3 antennas at the top of it. And depending on which antenna a cell phone connects to, we can tell which direction the phone is coming from. So based off of that, Ms. Becker's phone was coming from this direction where I'm pointing the arrow and not from the mall or the fry shack.
Whose phone were the texts and calls coming from?
Ma'am, they were all coming from Taylor Perkins' phone, who's a good friend of the defendant.
Now, finally, Detective, what do these records indicate about the defendant's location on March 6, 2020?
Well, ma'am, these records indicate that from 12:47 to 1:05 p.m. the day of the murder, the defendant was driving along Rock Creek Parkway, which I'm going to draw right now, in between these two lakes, and arrived at Mr. Brackman's property and was there from 1:05 to 1:17 p.m. the day of the murder.
Thank you. No further questions.
Thank you. Cross-examination?
Yes, Your Honor. May I proceed?
Yes, please.
Good evening, Detective. Now, let's get straight into it. You knew the victim prior to investigation, is that correct?
I did. Let's just say it wasn't the most pleasant experience to be cross-examined by Mr. Brackman.
And you thought he took cheap shots when it came to his work. Is that also true?
Objection, Your Honor. Relevance and improper character evidence.
Any response, Ms. Glass?
Yes, Your Honor. This is important and it's relevant because it illustrates that the witness may have a sort of bias due to her prior interactions with the victim, making this an important factor to consider in relation to this witness's credibility.
Ms. Rudowski?
Your Honor, I believe opposing counsel is using this for propensity to show that Detective Markowitz acted in accordance with a character trait that she had or a belief that she held. And if they're not using it for propensity, then it is not relevant.
I think in this instance, typically evidence such as this would be admissible to show bias of the witness. And so in that regard, the objection is going to be overruled. And you can answer the question, Detective.
Detective, would you like me to repeat my question?
Yes, please.
You thought that Mr. Brackman took cheap shots when it came to his work. Is that true?
As I said, it wasn't very enjoyable to be cross-examined by him, so that's yes to your question.
Moving forward, from the evidence that you analyzed, this appeared to be a break-in gone wrong. Is that true?
Ma'am, either way, Mr. Brackman died, but that's a yes to your question.
Respectfully, Detective, you're not answering my question with a simple yes or no. Was it apparent from the evidence that you analyzed that this appeared to be a break-in gone wrong?
Yes, ma'am, I believe I said yes.
You also believe that there was a possibility that this could have been the work of a disgruntled ex-client. Is that true?
Before other evidence presented itself, at the initial onset of my investigation, that is what I believed, yes.
And you believe this was an important factor to consider. Is that true?
At the very beginning, that's what I believed.
Yet you did not make any effort to investigate this alternative. Is that true?
Ma'am, could you clarify who you're talking about?
Apologies. My question was about whether you investigated if this was the work of a disgruntled ex-client.
Ma'am, I followed the evidence where it led me, and I initially looked at Mr. Brackman's phone, found Mr. Fuentes'
Markowitz, that was not my question. My question was whether or not you investigated that this could have been the work of a disgruntled ex-client. You did not. Is that correct?
And I followed the evidence, so I did not, no.
When you arrived at the house was in disarray, correct?
Yes, ma'am.
But there was no way for you to ensure that this was due to the break-in and not the normal state of the house. Is that also true?
Ma'am, there was broken plates and scuff marks, which was unusual, but there was no way for me to confirm that. So I guess that's yes to your question.
In your initial investigation, it seemed very unlikely that that Mr. Brackman's death, to clarify, had anything to do with his role in mock trial. Is that also true?
Well, I learned that he spent more time in mock trial than in his work as an attorney. And from what I saw from Ms. Fuentes, that's what it seemed like, ma'am.
Respectively, Detective Markowitz, I did not get a clear yes or no for that answer. In your initial investigation, it seemed very unlikely that Mr. Brackman's death had anything to do with his role in mock trial. Is that true?
Before I learned about his life and followed more evidence, that's what I believed, yes.
When you interviewed Cifuentes, is it true that she forgot to bring her cell phone?
Yes, when I initially interviewed Ms. Fuentes, I thought it was odd, but she might have been nervous.
So as an alternative to investigating yourself the phone, you had Cifuentes submit screenshots of the conversation with Ms. Becker.
I did, yes, ma'am.
And there were no timestamps in these messages to indicate when these messages were sent. Is that also correct?
I don't believe there were, ma'am.
And there's no imagery to indicate that it was Avery Becker's phone number that was being communicated with. Is that correct as well?
Ma'am, they looked like pretty standard text messages to me. There was no way to corroborate that. I had no reason to distrust Ms. Fuentes, though. So I guess that's.
But you had no way to confirm that the text messages were sent from Avery Becker's phone number besides just a contact name. Is that true?
Yes, ma'am.
Furthermore, even as an expert, you would say that the system in which cell phones pair with a tower is a complicated algorithm. Is that true?
It's complicated. However, I've used this analysis in over 50 cases, so I'm well qualified to talk about it.
But it's true that sometimes the best tower is not always the nearest one.
Yes, as I stated earlier, if a cell tower is busy, a cell phone will connect to one that is further away. This is rare, though.
The CDRs in this case indicated that Becker did not respond to any texts or phone calls on March 6th. Is that also true?
Correct. The texts and calls were not responded to, which is consistent with what we believed Ms. Becker was doing at this time.
And you are aware that my client claims that they were not in possession of the phone at this time. Is that true?
That's what Ms. Becker's lawyers told me. I wasn't able to talk to her directly.
But you are aware of the fact that she claims she was not in possession of the phone at this time.
That's what her lawyers claimed.
Moving forward, is it true that you can't be 100% certain that the communication with Avery's phone indicated she was driving along that pathway you described?
Ma'am, as I stated earlier, CDR analysis relies on patterns. Looking at the patterns, I'm relatively certain that she drove along Rock Creek Parkway, but not 100%.
But just to clarify, you're only relatively certain. There's no way for you to be 100% certain without a doubt in your mind that this is the exact pathway she was on.
Ma'am, nothing in my line of work is 100%, but I am fairly
Moving forward. You believe the victim had interrupted what was a robbery gone wrong. Is that correct?
Ms. Glass, if you could just hold on one second. I think Ms. Rudowski was making an objection.
Your Honor, badgering the witness.
Ms. Glass?
Your Honor, I believe I'm just asking a simple line of questioning and directing the witness to answer my questions when she's straying away from them.
Ms. Rudowski?
I'm not objecting to the questions themselves, rather that opposing counsel is cutting off my witness. I'd ask that she'd ask my witness to answer.
Okay, so in this case, what I will say, and it's a little more of a challenge with doing this over Zoom in the virtual courtroom, but I'm going to overrule the objection for now, but ask that attorneys and parties wait till each other is finished speaking in order to start their next question or next answer. Thank you.
Yes, Your Honor. May I continue?
Yes, please.
Would you like me to repeat my last question, Detective?
Yes, please, ma'am.
You believe that the victim had interrupted what was thought to be a robbery gone wrong. Is that correct?
Yes, ma'am. That's what I believe.
Was there anything taken from the house on March 6th?
Well, as you said, it was a burglary gone wrong. It ended in a murder, not a burglary, so it wouldn't have made sense for there to be things gone, ma'am.
So just to clarify, that was a no to my question, correct?
Yes, ma'am.
Moving forward to these Ring doorbell videos that you also reviewed, was anything, or can you identify the race of the person in the Ring videos?
The only substantial evidence we got was the height and build. So that's a no to your question.
And can you identify the gender of the person in this Ring video?
Again, no.
Can you identify the age of the person in this Ring video?
Only the height and build, ma'am. So that's again a no.
Can you identify anything about the intruder besides an approximate height and build?
No, ma'am.
Moving forward, one final question for you, Detective. Do you have any hard evidence such as DNA, fingerprints, or images of my client at the crime scene to tie her to this case?
Well, to answer the first part of your question about hard evidence, I believe I do. But to answer the things about physical evidence and actual photos of Mr. Becker, I don't.
So just to clarify, there's no physical evidence to tie my client to this crime scene, correct?
There's strong hard evidence, but none of the physical evidence you specifically talked about.
No further questions, Your Honor.
Okay, thank you. Any redirect requested by the people?
Briefly, Your Honor.
Okay.
Detective, you were asked on cross-examination about cell tower records. What is the likelihood that a cell phone would connect to a cell tower that is not the closest one to it?
Ma'am, it's not very likely at all. Furthermore, the bottommost cell tower, as I stated, connected to Ms. Becker's phone 3 separate times. One time might be an accident, 2 a coincidence, but 3 times is a pattern. And it's clear that Ms. Becker's phone connected to that cell tower that directly covered Mr. Brackman's residence.
You were also asked on cross-examination about the hard evidence that you had. What is the hard evidence that you have?
Ma'am, as I showed through my annotations of Exhibit 15, the hard evidence clearly shows the pattern. Again, that's really important with CDR analysis of Ms. Becker's whereabouts the day of the murder. She started off at her home, drove along Rock Creek Parkway, and was at Mr. Brackman's residence. That's hard evidence.
Thank you. No further questions.
Thank you. Any recross limited to the scope of redirect?
A brief one, Your Honor.
Okay.
Detective, you described this path along Rock Creek Parkway once again, and I would just like to ask you, for clarification purposes, can you be 100% certain that this is the pathway that Avery Becker was on during that time?
Again, nothing is 100% certain in my field, ma'am, so I'm not.
And apologies, I didn't mean to interrupt, but even if you could be 100% certain, you do recognize the fact that my client claims to not be in possession of this phone at the time, correct?
Ma'am, I believe that's awfully convenient, but that's what her lawyers did tell me.
No further questions, Your Honor.
Okay, thank you for your testimony, Detective Markowitz. Are there any further witnesses for the people?
The prosecution rests, Your Honor.
Okay, thank you. Is the defense ready with their first witness?
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand.
And as a reminder to the witness, you were previously sworn in, Mr. Daniels. So whenever you are ready with your examination.
Professor Van Owen, would you please state your first name and spell your last name for the court?
Blake Van Owen, VANOWEN.
Can you please tell the court what and where you teach?
Yes, of course. I teach a class on police practice and social justice at CU Denver.
And what credentials do you have that allowed you to become a professor?
Well, I received my master's degree through Ashford University's online program.
Before you obtained your master's degree and began teaching, what other hands-on experience did you have in crime scene investigation?
Well, I began my career at the Aurora Police Department, but after an incident with a young woman of color, I left the department. Though I was cleared of all my wrongdoings, I never quite managed to clear my own conscience. And pretty much since then, I've been working as a private investigator.
Have you ever testified as an expert witness before?
Yes, I have. I've testified in crime scene reconstruction 8 times, cell tower analysis 5 times, as well as general police practice 12 times, and consulted on over 100 cases.
Can you walk the court through a very general methodology regarding how you usually perform cell tower analysis?
Yes, of course. Though cell tower analysis may seem like an exact and precise science, that's not really the case. It's not remotely similar to GPS. It's more used for giving a broad area of where a phone might connect to a tower.
And how do you know this?
Well, obviously, I'm very familiar with cell tower analysis, and just reviewing this in many cases throughout my years, I've been using this same interpretation.
At this time, the defense moves to enter Professor Van Allen as an expert witness in crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Okay, any objection or voir dire by the people?
Yes, Your Honor, if I may conduct a brief voir dire.
Yes, please.
Good afternoon, Professor Van Allen. You were once a cop, correct?
That's correct.
You were only a cop for about 9 months.
Yes, that's correct. I left on my own accord.
And now I'd like to briefly talk to you about your background in crime scene reconstruction. You don't have any formal training in crime scene reconstruction, do you?
No, I don't, but I've been working in it for many years now, and I believe that my experience has made me a good expert for crime scene reconstruction.
Of course, but you don't have any formal training, do you?
I never received any formal training, no.
Objection, Your Honor. Under Rule 702, this witness can be entered as an expert witness due to extensive field experience.
Okay, and so any response to that, Ms. Walters?
Yes, Your Honor. I'm simply just trying to lay the foundation for this witness so I can object under Rule 702. If I could finish my voir dire, it would make a little bit more sense.
Okay, Ms. Liebman, any reply?
No reply. I just stand by my objection.
Okay, so the objection will be overruled, and Ms. Walters will be allowed to finish her or continue with her voir dire.
Yes, Your Honor. And you don't have any certifications in crime scene reconstruction, do you?
I never received any certifications.
Your primary job has never been in crime scene reconstruction, has it?
No, it hasn't. I'd like to consider myself a sort of jack of all trades in police work.
Now, I'd briefly like to talk to you about your experience with cell phone data. You don't have any formal training analyzing cell phone data, do you?
No, that's true, but I've been working in cell tower analysis for a very long time now.
And you don't have any certifications?
No, I didn't receive anything in cell tower analysis.
And your primary job has never been in cell phone data analysis, correct?
No, once again, I choose to focus on sort of the broad police work, and that happens to include cell tower analysis.
Thank you. At this time, I object to Professor Blake Van Owen being tendered as an expert in crime scene reconstruction, general police practices, and cell phone tower analysis.
Okay, and what's the basis for the objection?
I think that he has a lack of, or under Rule 702, I think he has a lack of experience, knowledge, training, skill, or education, specifically pertaining to cell phone data analysis. He has no formal education. He holds no certifications in this field. His primary job has never been in cell tower analysis, and he never specified what his previous experience in cell phone tower analysis was.
Okay, thank you, Ms. Liebman.
I would actually say that this witness should be allowed in as an expert witness in crime scene reconstruction and in cell tower analysis due to Rule 702, due to his extensive experience and training in the field and his many years as a CSI, not a CSI, a private investigator. Additionally, this witness demonstrated his extensive knowledge of cell tower data when I laid the foundation for his knowledge of cell tower data. He walked us through his general methods. He talked about how he approaches it, and also I would disagree with the opposing counsel's objection that my witness should not be entered in general police investigation tactics, as he teaches a class on this, and he got his master's degree to teach a class on this.
Your Honor, if I may respond,
Yes, please.
I have no objection to Professor Blake Van Owen being tendered as an expert in general police practices, simply cell phone tower analysis, because the only foundation she has laid is that he has testified as an expert previous times, but that doesn't show that he has worked in cell tower analysis, simply that he has testified as an expert in it.
Okay, so typically in a case like this, what I would say is that witnesses can gain their expertise from a variety of ways. That includes attending classes and programs, completing trainings, but also through in-the-field experience. And in this case, the court is going to find that Professor Van Owen does meet the standard under the Rule 702 and will be admitted into as an expert on all the grounds requested by the defendant. The objection goes to the weight that the jury will give to Professor Van Owen once they're considering his testimony, and all the issues raised by the people can be addressed on cross-examination.
May I continue?
Whenever you're ready.
Oh, thank you. Given your time with the Aurora Police Department, Professor Van Owen, and as a private investigator, how would you describe your level of familiarity with crime scene analysis?
I'd say I'm very familiar with crime scene analysis.
Did you do a formal report on this investigation?
I did.
Could the trial technician please pull up what has been marked for identification purposes as Exhibit 20 for the purpose of identification by the witness? Professor Van Owen, do you know what this is?
Yes, this is my report on the crime.
And do you recall writing your report during this investigation?
I do.
Is this a fair and accurate representation of the report that you wrote during that time?
Yes, it is.
Your Honor, I move for the admission of Exhibit 20.
Any objection?
Yes, Your Honor, hearsay.
Okay, any response?
Yes, this is an exception to hearsay under Rule 8035, past recollection recorded.
Any reply to that?
I'm sorry, could she say that again? My audio went out a little bit.
I believe she said Rule 8035, past recollection recorded.
Yes, Your Honor. We ask that this exhibit be entered with a limiting instruction to only be used for no objection.
Okay, with no objection, then Exhibit 20 will be admitted into evidence.
Permission to publish Exhibit 20 to the jury as it's only been pulled up for identification purposes.
Yes, please.
Could the trial technician please scroll to page 4 of this exhibit? Professor Van Owen, could you explain how the structure of cell tower coverage relates to the location of a person?
Yes, of course. Typically, these cell towers operate with a 6-mile radius with 3 different antennas, each covering a 120-degree arc around the cell tower. But just because sometimes if a cell tower is busy, a phone that was farther away might connect to another cell tower. So getting exact location from these towers is it's not possible.
So is this effective?
While it is effective in getting sort of a broad area at which a phone could be when it connects to the tower, it doesn't give an exact area or location.
Were you able to review records of the cell tower communications?
We were not, unfortunately. The prosecution never collected their records.
Moving on. While you were compiling your report on this investigation, did you take any photographs?
I did.
Could the trial technician please pull up Exhibit 21 for the purpose of identification by the witness? Is this one of the photographs you took?
I did take this photo.
Does this picture accurately reflect the picture that you took yourself?
Yes, it does.
Your Honor, I move for the admission of Exhibit 21.
Any objection?
Yes, Your Honor. I object, more prejudicial than probative under Rule 403 on the grounds of misleading the jury.
Okay, and just to clarify, is this the same knife that we saw in Exhibit, I think it was 5?
Yes, Your Honor, this one is just taken, that was not from the scene.
Actually, Your Honor, this is not the same knife. This is a knife from Professor Van Owen's own house of the photograph that he said he took himself. This is a completely different knife. It only goes to show the angle that the knife is held at.
Okay, any reply to that, Ms. Walters?
Yes, Your Honor, I stand by my objection that it's more prejudicial than probative on the grounds of misleading the jury. We have seen Exhibit 5, which has already been admitted into evidence, depicts the knife that was used in the murder. And additionally, this knife might confuse the jury, and it is more prejudicial than probative because it shows which the way that the defendant held the knife.
Okay, and so there is some concern that this exhibit is more prejudicial than probative, but given the testimony that Professor Van Owen is going to give, the court will admit Exhibit 21, and the prosecution will have an opportunity to cross-examine the professor on what this picture is actually showing so that the jury has a better understanding. So the objection is overruled and Exhibit 21 will be admitted.
Your Honor, may I just clarify one thing very quickly?
Please.
This is not the same knife that was used in Exhibit 5. This is not the knife that was found at the scene.
Correct.
Okay, thank you. Why did you take this photograph, Professor Van Owen?
Well, as you can see, the indent on the top of the knife handle is typically where one would put their fingers, whether they were holding the knife in a downward position or over their head.
And what is your expert opinion on the position of the intruder relative to the position of the victim?
I believe, due to the way that one might hold a knife, the most likely explanation is that the victim was sitting down and the intruder came up from behind the victim and stabbed him from behind.
Let's move on to the ring videos. In reviewing the prosecution's evidence, did you get a chance to analyze these ring videos?
I did analyze the ring videos.
Could the trial technician please display Exhibit 11 and play it? Is Exhibit 11 one of the ring, or how do you know that this is one of the ring videos that you're viewing?
I remember.
And did you analyze this specific video during your investigation?
I did.
Is this video fair and accurate representation of the video you reviewed?
Yes, it is.
Permission to enter Exhibit 11 into evidence?
Any objection from the people?
No objection, Your Honor.
Exhibit 11 will be admitted into evidence.
Permission to publish Exhibit 11 to the jury?
Yes, please.
Professor Van Owen, in your expert opinion, what can you determine about the intruder from these videos?
Well, as you can see, the intruder is both masked and gloved and fully clothed. The only thing that we can really determine from this video is somewhat of a stature and height of the intruder.
Did you know that the prosecution is using these videos to connect Avery Becker to the scene of the crime?
I did.
Do you think that these exhibits connect Avery Becker in any way?
No, they don't. Just because the person in the video happens to be the same stature as Avery Becker doesn't necessarily mean anything.
Did you also review the photographs of the scuff marks?
Yes.
As an investigator, would you consider those scuff marks worthy of note?
No, I wouldn't. You can't carbon date scuff marks. We have no idea when those marks are made. They could have been made years ago, and we have no possible way of knowing.
Are you aware that the prosecution considers these scuff marks indicative of a struggle?
I was also aware of that, yes.
You agree?
I don't believe that these scuff marks point to anything. I'm sure most homes have scuff marks.
Let's move on. During your investigation, did you get the chance to look into any other students at the school?
Yes, I did.
Which students stood out to you?
Well, a student by the name of Blair Rollins.
And why did Blair Rollins strike you as familiar?
Well, he was also a similar height and stature to the defendant, Avery Becker.
In your investigation, did you also look into the case of Blair Rollins' father?
Yes, I did.
And what happened in this case?
Well, you see, Brackman was the defendant attorney in Jonathan Rollins, Blair Rollins' father's trial. And I have heard that due to a few mistakes from Brackman, Jonathan Rollins ended up losing the trial and even threatened to harm Brackman.
In your expert opinion as a crime scene investigator, would you say that failing to save one's father from prison is a powerful motive?
I believe that's an extremely powerful motive, much more powerful than getting kicked off the high school mock trial team.
No further questions, Your Honor.
Okay, cross-examination.
Yes, Your Honor. Good afternoon, good morning, Professor Van Owen. Let's start by talking a little bit more about your background. As you answered on what you were a police officer, correct?
That's correct.
You became disillusioned with police work.
Yes, I believe that some of their malpractices probably need to be fixed, and I believe I could do that better in private investigation than I could on the force.
And you became disillusioned because of its tactics and techniques?
I believe that some of its techniques are flawed and are not necessarily needed or necessary in the arresting or any such in during or when in police work.
And as a result of these tactics and techniques, you quit.
I did, yes.
You now teach a college course on police practices.
Yes, at U Denver.
And social justice.
Yes.
And you frequently testify as an expert.
That's correct.
And you only ever testify for the defense.
Yes, mostly. That's what I do as a private investigator.
Your Honor, objection relevance.
Your Honor, this is relevant because it goes to the weight of the witness's testimony, because it exposes some potential bias that the witness may have.
Any reply, Ms. Liebman?
No reply, just stand by my objection.
Okay, the objection will be overruled. The testimony or proposed testimony goes to the credibility of the witness in this matter.
And Professor Van Owen, you consider yourself a check on the power of policing.
I would like to consider myself that, yes.
Now, let's talk about some of your findings. You agree that the evidence found at the scene points to an intruder entering the home.
Yes, it does.
And you're aware that scuff marks were found at the scene.
Yes, I've already explained that.
And you were aware that a chair was found over in the dining area knocked over.
Yes.
That a broken plate was found on the floor.
That's correct.
That a knife drawer was found in the kitchen, left open.
Yes, I do know this.
That there was an empty slot in a knife block on the kitchen counter.
Yes, there was.
And that the defendant wasn't at school on March 6th.
That is true, but he has a reasonable explanation for that, and nor was Blair Rollins.
I'm not asking about Blair Rollins. I'm simply asking that the defendant wasn't at school.
No, him and his friend were not at school that day. They were looking for his phone.
Now, let's briefly talk about your cell phone tower analysis. You would generally agree that a cell phone usually connects to the nearest tower.
Yes, but it's a very busy area, and the likelihood of it connecting to a tower further away is not completely unreasonable and somewhat likely.
Do you think it's possible that a phone could connect to a more distant tower?
Yes, very possible.
But you agree that it is significantly more likely for it to connect to the nearest tower?
Yes, but in an area this busy, it's not unlikely at all that it connect to a further away tower.
Now, cell tower 1197 covers the Brackman home.
That's correct.
And a cell tower has 3 antennas.
Yes, each corresponding to a different 120-degree arc.
And antenna number 1 of cell tower 1197 covers the Brackman residence.
That's correct.
And Avery Becker's phone connected to cell tower 1197 of antenna 1.
Yes, it did.
And not only did it connect once, but 3 separate times.
Yes, but again, that only corresponds to a 120-degree arc and a 6-mile radius, and we don't even know if it connected to that tower because it was nearest or because the other towers were busy.
Yes, I'm just simply asking if Avery Becker's phone connected to cell tower 1197, antenna number 1 of cell tower 1197, and the answer is yes, isn't it?
It did connect to it, yes.
And it connected to cell tower 1197 at 1:05 p.m.
That's correct.
Again at 1:06 p.m.
Yes.
and finally once more at 1:17 p.m.
Yes, which only points towards an area.
Sorry, was there an objection, Ms. Liebman?
Yes, where's the question in this?
I can't hear what you're saying.
Oh, my apologies. There doesn't seem to be a question.
Ms. Walters?
Yes, Your Honor. I'm simply asking, I'm asking the witness to confirm that Avery Becker's phone did connect to cell tower 1197 at 1:05, 1:06, and again at 1:17 p.m.
The object. Please go ahead, Ms. Liebman.
Opposing counsel was simply stating that it did connect at those times, not asking the witness whether it did.
I think the attorney, Ms. Walters, was asking if Professor Van Owens agrees that those are the times. So that's a proper form of a question. So the objection is overruled.
Now, Professor Van Owen, Avery Becker's phone connected to cell tower 1197, which covered the Brackman residence 3 separate times around the time that Brackman was murdered, correct?
Yes, the phone did connect.
Answered.
Any response, Ms. Walters?
Yes, Your Honor. I'm simply, this has not been asked and answered because I have not. I'm just clarifying that Avery Becker's phone did connect to the cell tower 3 separate times at the time that Mr. Brackman was murdered, and I have not asked that question yet.
Ms. Liebman?
The response, I just stand by my original objection.
Okay. It's not unusual for attorneys to tie in a series of questions into sort of a cumulative question, so the objection is overruled. And you can re-ask the question.
Yes, Your Honor. Now, Professor Van Owen, Avery Becker's phone connected to cell tower 1197, which covers the Brackman residence 3 separate times around the time that Mr. Brackman was murdered, correct?
Yes, as I've stated.
Thank you. No further questions.
Okay. Any redirect from the defense?
No to redirect at this time, Your Honor.
Okay. Thank you, Professor, for your testimony this morning. Is the defense ready with their next witness?
The defense calls to the stand Mr. Taylor Perkins.
Okay, Mr. Perkins. Just as a reminder, you were sworn in at the start of this proceeding, so you are under oath, and whenever you are ready, Ms. Bachner.
Yes, Your Honor. Good morning, Mr. Perkins. Please state your name and spell your last for the court.
Taylor Perkins, Perkins.
So, Mr. Perkins, can you tell me a bit about yourself?
Well, I went to CHS, and I was on the mock trial team there.
And what's your relationship with the defendant, Mr. Avery Becker?
Avery Becker is a good friend of mine.
And how do you know the victim, Mr. Brackman?
Mr. Brackman was actually the coach on our mock trial team.
You mentioned you were on the mock trial team. What happened?
I was on the mock trial team, and then Avery got demoted, and I just really was not having fun on there. I was a lawyer, and I didn't want to be a lawyer, so I just decided it wasn't my year, and I quit.
And what was Avery like on the mock trial team?
Avery was the best on the team. Although he really didn't try his hardest, he still outperformed everyone on the team.
And what importance did Avery have on the success of the mock trial team and tournament?
It was very important. Usually if he was there, we would win a competition or tournament, and if he wasn't, we would lose.
And did Avery win any awards at the last tournament?
Yeah, I'm pretty sure he won best closing and best attorney.
And what was Avery's relationship like with Mr. Brackman?
They had a little feud.
Can you tell me a bit about the feud?
Basically, Coach Brackman would just get annoyed that Avery wasn't trying his hardest and still performed extremely well.
Let's talk about the night of March 5th, the night before the murder. What did you do after school that evening?
Sorry, could you repeat that?
Yes, of course. What did you do the night of March 5th?
Oh, the night of March 5th, Avery came over to my house and we played some games on our phones, and then we went to Fry Shack.
And what happened at the Fry Shack?
At the Fry Shack, we got food, and then we ran into the mock trial team there. And then basically everyone on the mock trial team kept on telling Avery how unfair it was that he got kicked off the team, and he got pretty upset. So he went to the bathroom.
And what happened when he went to the bathroom?
When he went to the bathroom, he left his phone on the table.
And can you tell me about what happened that night with Avery's phone at the Fry Shack?
I know that Alex Cifuentes was playing games on it or something like that.
And why did you guys leave the Fry Shack?
We left the Fry Shack and we went to cool down at the mall.
And what happened at the mall?
At the mall, we kind of had a pretty good discussion about Avery getting kicked off the team, and we were pretty deep in conversation. We also looked in some stores.
Can you tell me about the last time you saw Avery with his phone?
At Fry Shack that night of March 5th.
And you haven't seen it recently?
No, I have not.
What did you do the following morning of March 6th?
So basically, usually Avery will pick me up for school if we have first periods off, and that day we did. And I texted him asking if he was coming to pick me up, and he eventually did, but he never responded to my text. So when we were in the car, I mentioned that he never responded to my text, and then he realized that his phone was missing.
So what did you do for the entire day?
We searched for his phone.
And where did you go to search for his phone?
We pretty much retraced our steps, went to the mall, to the Fry Shack, looked around a little bit, and then we went back to the Fry Shack at the end of the day.
So just to clarify, you were with Avery the entire day?
Oh yes, the entire day we were searching for the phone together.
Can you tell me if you went anywhere near Mr. Brackman's house?
No, we did not go anywhere near the area.
Can you tell me a bit about Alex Cifuentes?
Alex Cifuentes was another mock trial member, and Avery and her had a little bit of a feud as well.
Can you tell me a bit about that feud?
Basically, Avery always got the roles that Alex wanted because of Avery's natural talent at mock trial.
Objection, Your Honor. Lack of personal knowledge.
Any response, Ms. Bachner?
Yes, Your Honor. Mr. Perkins was at the mock trial with Mr. Becker and Ms. Cifuentes and would have been easily able to perceive this feud with his own eyes. It wasn't a speculation.
Your Honor, may I respond?
Any reply? Yes, please.
I'm not objecting to the testimony about the feud. I'm objecting to the testimony that Avery got the roles that Alex wanted, as there's no way for Mr. Perkins to know this.
Okay, so what I'll say in this instance is, unless there's further information as to why Mr. Perkins knows this as a fact, the court will allow the testimony as his own personal belief regarding why things are happening, but the court will instruct the jury to disregard this as there being a factual basis without further foundation laid.
May I lay some more foundation?
Please.
So when you guys auditioned for roles in mock trial, did Alex ever get the roles Avery wanted?
Well, usually when we auditioned for roles, Alex and Avery would audition for the same role, and Avery would usually always get that role.
Thank you. Do you know Blair Rollins?
Yes, I do.
Can you tell me a bit about Blair Rollins?
Blair Rollins, I know Blair Rollins from school, not mock trial. Blair Rollins was a kind of a weird character, but that's pretty much all I know about him.
And can you tell me anything about the relationship between Blair Rollins and Mr. Brackman?
Basically, Blair Rollins' father was involved in a court case with Mr. Brackman was the
Objection,
attorney
Your
for.
Honor. Lack of personal knowledge.
Any response, Ms. Bachner?
Yes. Rollins' father was sent to prison in a case that was known to all the students, and also Mr. Brackman, as lawyer for Mr. Rollins, was also the mock trial coach, and everybody would have known about this case in the results.
Ms. Rudowski?
Your Honor, Mr. Perkins would not know the details of a court case that he was not present for. And additionally, if he did know this, the testimony is based on hearsay.
Ms. Bachner, can you lay any foundation as to Mr. Perkins' knowledge?
Yes, of course. Mr. Perkins, did you know about a court case that Mr. Brackman was in that he lost?
Yes, I know that it was talked about on the team a lot with as Mr. Coach Brackman was our coach.
And can you tell me a bit about Blair Rollins' father?
Blair Rollins' father was involved in that case and was sent to prison.
And
Again,
did
Your
Mr.
Honor,
Brackman,
objection, lack of personal knowledge.
Okay, so I think, and this is the same objection that we heard previously. And so I guess what I would say is Mr. Perkins can testify about his knowledge of that as to what he understood happened to the person being described, but he cannot testify as to the statements that, or at least at this point, that formed the basis for that knowledge. So the court will overrule the objection as to whether or not he knew that this witness or the individual was in a trial or went to prison.
yes, Your Honor. From what you know, what do you know about the results of this case?
I know that Blair Rollins' father was sent to prison and his lawyer was Coach Brackman.
Thank you. And can you tell me anything about Blair Rollins and his whereabouts since the murder of Mr. Brackman?
Since the murder of Mr. Brackman, I have not seen him. I have no idea where he is.
And if I were to put Blair Rollins and Avery Becker next to each other, how would you say they compared physically?
They have almost the exact same body type without like the distinguishing like features like up close. So if you saw them from like afar or a video where you really couldn't tell, they would look almost identical.
Thank you, Mr. Perkins. No further questions.
Okay, great. Cross-examination by the people.
Yes, Your Honor. Now, Mr. Perkins, on direct, you talked about the day that Avery's phone went missing.
Yes, I
And
did.
you said that you saw Alex playing on the defendant's phone at the Fry Shack, correct?
Yeah, I think he was playing games on it or something.
But Mr. Perkins, that's not in your witness statement, is it?
I saw it happen.
Mr. Perkins, is it your testimony that that is in your witness statement?
I never said that.
Are you testifying that you did see Alex Cifuentes on the defendant's phone?
I'm just saying that I heard Avery tell me that he was playing with his phone.
Your Honor, permission for my co-counsel to screen share Taylor Perkins' affidavit?
Yes, please.
Now, read along silently as I read this aloud, starting at line 61. Everybody was telling Avery how unfair it was that Coach kicked Avery off the team, even Alex Cifuentes, which seemed almost sincere. But Alex had a way of being totally insincere in a passive-aggressive way. Avery got upset and kind of stormed off to the bathroom. Avery's phone was still on the table, I think. Now, Mr. Perkins, nowhere in there does it say that you saw or Avery told you that Alex Cifuentes played on the defendant's phone, correct?
When I made the statement, I must have forgot to include that.
But Mr. Perkins, you were aware that you had to include all relevant information and that you were able to update your affidavit if any occurred to you.
Yeah, but I didn't think it was extremely relevant.
But Mr. Perkins, just to clarify.
Objection, Your Honor. Asked
What
and
grounds?
answered. The attorney is badgering the witness, and he clearly already stated his opinion and what he believed happened.
Ms. Rudowski?
Your Honor, this is not asked and answered. I'm clarifying, and the witness did not give a clear answer to my question.
Okay. Ms. Bachner, any reply?
The witness did say that he probably just forgot to include it. He said it multiple times, yet she continues to badger him.
Okay, and so it's not clear to me that Mr. Perkins in this instance has clearly answered the question. So I'll overrule the objection and allow the question one more time with a direction to the witness to please answer the question that's asked.
But Mr. Perkins, the statement that you saw Alex or that Avery told you that Alex was playing on his phone is nowhere in your witness statement.
Again, I didn't think it was, as you said before, relevant information needs to be included. I really didn't think it was a relevant piece of the case.
All right. Co-counsel, you can stop screen sharing the affidavit. Now, Mr. Perkins, I want to start by talking a little bit about the defendant's relationship with Mr. Brackman.
Sure.
You were on the mock trial team with Avery Becker, correct?
Oh yeah, I was.
Mr. Brackman was your coach?
Yep.
So you observed their relationship throughout this period of time, correct?
Yeah, I was there and I saw everything that was going on, usually.
Mr. Brackman didn't like how Avery prepared.
Well, it was more like how he didn't like that he didn't prepare, but yeah.
In fact, he called Avery unprepared.
Yep.
He called him lazy.
I think he could have said that.
He said that he didn't try hard enough.
I mean, he didn't really try that hard, but he still outperformed everyone on the team.
But Mr. Brackman told Avery that he didn't try hard enough. Isn't that correct?
Yeah, they had some tension, and it's probably just a little heat coming off of.
Objection, Your Honor.
On what grounds?
Under Rule 801 hearsay, this is an out-of-court statement taken for the truth of the matter asserted. Mr. Perkins did not actually hear this. Avery told him this.
Ms. Radowski?
Your Honor, two responses to that. I'm not using the statements for the truth of the matter, but the effect on the listener. And as to what Avery told him, that is a statement of a party opponent under 801 D2.
Ms. Bachner, any reply?
I stand by my objection.
Okay, the objection will be overruled and the witness will be allowed to testify.
Now, Mr. Perkins, Mr. Brackman told Avery that he didn't try hard enough.
He said a lot of rude things.
And all of this seemed to bother Avery, didn't it?
Yeah, I mean, usually it didn't really, but sometimes it got to him.
Mr. Perkins, you and Avery were on the mock trial team for 4 years, correct?
Well, it would almost have been 4 years, but I quit halfway through the season, so.
But Mr. Brackman, it was almost 4 years that you were on the mock trial team.
Mr. Brackman?
Or excuse me, Mr. Perkins. It was almost 4 years that you were on the mock trial team with Avery Becker, correct?
Yeah, yep.
And Mr. Brackman was your coach for all 4 of those years?
Yeah, the whole time I was on the mock trial team.
Mr. Perkins, I would now like to talk a little bit about the defendant's phone.
Okay.
The day March 6th, 2020, you say that you were with the defendant all day looking for his phone.
Yep.
But the defendant always had his phone with him, didn't he?
He usually had it. It was like he liked to play games on it and stuff, but like what happened at the Fry Shack the night before, he was in complete dismay and he was really upset. So, and then I guarantee he went to bed and then forgot about it and then just rushed to pick me up in the morning. So I can see how he literally would have not known.
Mr. Perkins, that wasn't quite my question. All I asked was if the defendant always had his phone with him, and he did, didn't he?
Yeah, like anyone.
In fact, that phone was like a third kidney to him, correct?
Yep.
And just to clarify, it wasn't until the morning of March 6th that Avery realized his phone was missing.
Again, the night before was quite, stressful for him. He was in a terrible mood, and I can see like how after he dropped me off, he would have gone straight to bed, and then in the morning he was probably in a rush, so he literally would not have known that he forgot his phone at the Fry Shack.
Mr. Perkins, that wasn't quite my question. All I asked was if it took until the morning of March 6th for Avery to realize that his phone was missing.
When he realized his phone was missing is when I told him that he didn't respond to any of my texts in the car to school on the way to find his phone.
And that was the morning of March 6th, correct?
Yes.
Now, Mr. Perkins, 1 week before regionals, you quit the mock trial team, correct?
Yeah, I did.
You quit in support of your friend, the defendant, who was kicked off.
That wasn't the only reason. I was a lawyer and I really did not enjoy being a lawyer. I'm also not the biggest fan of mock trial. And then Avery getting demoted kind of just sent me over the edge. And I was just like, not my year. And I kind of just quit.
But Mr. Perkins, Avery was a factor in your decision to quit the mock trial team.
Amongst many other.
Now, you know the defendant well, correct?
Yep.
In fact, you're the defendant's best friend.
Yep.
And you are also the only one here in court today who can corroborate Avery's alibi for March 6th.
Yeah, I don't know who else would have been. If we knew anyone at the mall, they could have for sure, but we don't really know anyone in the stores. So it would just been me and him.
But Mr. Perkins, that is a yes to my question. You are the only one here in court today who can corroborate Avery's alibi.
Yeah, I was with him the whole day.
Thank you. No further questions.
Okay, any redirect requested by defense?
Just a brief one, Your Honor.
Okay.
Just to clarify, Mr. Perkins, you were with Avery for the entirety of the day on March 6th.
Yep, from when he picked me up for school until he dropped me off later that night.
No further questions. Thank you.
Any recross limited to the scope of the redirect?
No recross, Your Honor.
Okay, thank you, Mr. Perkins, for your testimony this morning. Is the defense ready with their next witness?
Yes, Your Honor. The defense would like to call Avery Becker to the stand. Permission to proceed?
Yes, Mr. Becker, as a reminder, you were placed under oath at the start of this trial. So whenever you are ready, Ms. Glass.
Good evening, Mr. Becker. Can you please state your full name and spell your last for the court?
Avery Becker, Becker.
Mr. Becker, where did you attend school?
I was a senior last year at Colorado High School, or CHS.
Did you participate in any activities at Colorado High School?
Yeah, I did mock trial for all 4 years.
How well did you perform in mock trial?
Mock trial came really naturally to me. It's something that I didn't really have to spend a lot of time pre-thinking of my questions. I could kind of come up with crosses by just listening to the witnesses, and it's something that came really naturally to me. And I was looking forward to do well at state.
Did you earn any achievements during your time in mock trial?
I did. I won best attorney at regionals and also best closing.
Moving forward, why did you join mock trial?
At the start, the reason I joined is because it was more of a
relevance.
Any response?
Your Honor, I'm just trying to lay some foundation to establish the relationship between the defendant and our victim, Mr. Brackman.
Any reply?
Yes, Your Honor. I believe the question was talking about why this witness joined mock trial. That wouldn't tend to say anything about the specific relationship. Ms. Glass wasn't asking what her Mr. Becker's relationship was to Coach Brackman, how they got along in practices, or anything of the sort. She asked why he joined mock trial, which is irrelevant.
Okay, so typically in a case like this, we would allow a little bit of introductory testimony and leeway, so the objection will be overruled.
Mr. Becker, would you like me to repeat my question?
Yes, please.
Why did you join mock trial?
At the start, it was just more of a way for me and my friend Taylor Perkins to kind of spend some more time together. And I actually started to enjoy it later on, but at the start, that's just what it was.
Now, Mr. Becker, how did you know Mr. Brackman?
He was the coach of the mock trial team, so I know him very well.
And how would you describe your relationship with Mr. Brackman?
Unfortunately, it was not that great. He always thought I was lazy and I didn't work as hard as he thought I should, which I didn't need to because I was naturally very good. But he always would get mad at me and saying that I needed to follow his scripts, or if I ever went off the scripts, he would get mad at me for that. And he would call me lazy and say that I didn't work as hard as I needed to.
Did you receive any repercussions for your lack of preparation or straying away from the scripts?
After one practice, I remember he actually demoted me to the B team after I didn't follow one of his scripts.
And did you remain on the B team for the remainder of your senior year?
No, my friend Taylor, in fact, realized that he wasn't really enjoying it. I mean, he didn't want to be an attorney, and he knew that if he quit, then Brackman would have no choice but to put me back on the team. And so all those factors together just kind of led to him doing that, and that's exactly what happened.
Once you were back on the A team, how did the rest of your season go?
It went really well. We did great at regionals, and I won best attorney and best closing, as I previously said.
How did Mr. Brackman indicate that you performed?
So the practice after, he went off on me in front of everyone. He said that I didn't deserve the award. He said that I just rely on my good looks and that I was lazy and I didn't deserve it.
How did you react to Mr. Brackman's poor reaction?
I was upset. I felt bad because I felt like I was one of the major factors in why our team had won and did well at regionals, and I was hurt.
Did anything occur after you left the practice?
Yeah, so I've done some pretty dumb things in my life, but this is definitely the biggest mistake of my life. I took what I thought was an expo marker. I actually grabbed it from a whiteboard because I thought it was just an expo marker, and I went out to his Porsche. And it was just supposed to be kind of a small way for me to get back at him. I wrote worst attorney award right on his white Porsche. It was just a way for me to kind of get back at him. My plan was to wipe it off after, but I later found out that it was a permanent marker. So I ruined his car.
Did you receive any repercussions for the damage to his car?
Yeah, he immediately kicked me off the team.
How did you feel about damaging his car?
I felt so guilty. I never intended to permanently deface his car. I felt terrible about it. When I went home and I talked with my mom about it, I was a little embarrassed to tell her the truth. So I didn't tell her that I had defaced his car. But after that conversation with her, she told me I needed to go apologize to him. And I realized that it was my own fault. I was angry at the beginning of the conversation, but by the end, I realized that it was my own fault. I felt really guilty, and I just wanted to apologize to him. I offered to get a job over the summer. I offered to scrub it off his car. I really wanted to apologize to him.
And did he ever respond to your apologies?
Unfortunately, no, he never listened to any of them, and it's a shame. I was never able to apologize to him in person before he was killed. It's very sad.
Moving forward, where were you on March 5th?
So March 5th, the night before, me and Taylor were hanging out, and we went to the Fry Shack, and then afterwards we went to the mall for a little, and we went over to Taylor's house, and then I went home that night.
Did anything strange happen while you were with Taylor Perkins?
So I didn't realize that until the next morning, but I lost my phone the night before. Now, I think I left it at the Fry Shack. That's the last place I remember having it. It was sitting on the table. And that's just the last place I can remember having it. But I didn't realize that till the next morning.
Moving forward, do you know Blair Rollins?
Oh, yeah. He was another senior at Colorado High School at the time.
Would you say you knew Blair Rollins fairly well?
Yeah, I knew him pretty well. We go to the same school, so we're around each other a lot. And I had classes with him. He's kind of a weird kid, but I didn't know him.
And would you say you were also aware of the relationship between Blair Rollins and Mr. Brackman?
Oh, yes. The whole team was very aware. It was one of the most common things we would talk about.
From a general view, how would you interpret the relationship between Blair Rollins and Mr. Brackman?
Very bad. Mr. Brackman represented.
Sorry, just 1 second. Mr. Becker, Ms. Ryan, what's the basis for your objection?
Lack of foundation, Your Honor.
Ms. Glass?
Your Honor, I believe I've laid proper foundation as to how Mr. Becker knows Blair Rollins, as he was a classmate of his, and how he knows Mr. Brackman, and how he has witnessed the relationship between the two through his experience in mock trial and through fellow mock trial members discussing it.
Any reply, Ms. Ryan?
Yes, Your Honor. I don't believe this witness testified that they actually viewed interactions between Mr. Brackman and Blair Rollins, and that it was something that the team merely talked about, which would be based on hearsay.
I think given the nature of the testimony that the court's heard to date, the court's heard sufficient information to say that this witness does have some basis for that information. So the court will overrule the objection and you can testify, Mr. Becker.
Mr. Becker, would you like me to repeat my question?
Yes, please.
From a general view, how would you interpret the relationship between Blair Rollins and Mr. Brackman?
It was not good. Blair Rollins' father was sent to prison on a case that Coach Brackman actually represented. And I know that Blair Rollins was not happy about that.
How would you describe Blair Rollins physically?
Oh, we look very similar. You know, if anyone were just to look, we were about the same height and body shape. You know, if someone were to see us in like dark or poor lighting or bad camera quality, we would look the exact same.
Have you seen Blair Rollins since the murder of Mr. Brackman?
I have not.
One final question for you, Mr. Becker. Would you ever do anything to intentionally or unintentionally harm Mr. Brackman, or have you ever?
Never. I would never do something like that.
No further questions, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. Good morning, Mr. Becker. I have a couple of questions for you. You're
Morning.
good friends with Taylor Perkins, aren't you?
Yeah, we're best buds, I would say.
And you claimed that the two of you were at the mall together on March 6th. Isn't that true?
Well, we were looking for my phone there. Yeah.
And you weren't at school on March 6th, were you?
No, we'd already taken the English quiz, and you know, it was our senior year. We figured we could skip a day of school.
And because you weren't at school on March 6th, Taylor Perkins is the only other person in this courtroom who can even claim to have seen you on March 6th, correct?
Well, we don't know anyone at the mall, but they could probably say we were there or at the Fry Shack. But Taylor Perkins and I were together the whole day looking for my phone.
Mr. Becker, that wasn't quite my question. I'm just asking if Taylor Perkins is the only other person here who actually saw you that day. And the
Well,
answer
if we're
to
just
that-
talking about in this courtroom, then yes.
And you also claim that you lost your phone on March 5th, true?
I didn't realize it till the next morning, but in fact, I did lose my phone the night before.
And before that happened, Mr. Brackman used to coach you at mock trial.
Well, for 4 years, yes, he did.
And Mr. Brackman always told you that you were lazy, didn't he?
He would tell me that a lot. Yeah, I did.
He told you that, or Mr. Brackman never gave you credit for the work that you did he?
I never felt that he did. He never gave me the proper credit I felt like I deserved, because I felt like I did very well, but he thought I didn't follow his scripts, and he took offense to that.
And just 1 month before your regional tournament, Mr. Brackman demoted you from the A team down to the B team, didn't he?
Mm-hmm. He did.
Mr. Brackman took away your closing argument, didn't he?
Unfortunately, yeah.
And he didn't originally want to let you back onto the A team.
Well, no, it was because Taylor quit the team. That's the reason why he had to.
Exactly. Only after your good friend Taylor Perkins quit did Mr. Brackman let you back onto the A team.
Yeah.
And at regionals, you won some awards, didn't you?
I did.
And at the very next practice, Mr. Brackman told you you didn't deserve those awards.
No, he said that I just relied on my good looks and that I didn't follow his scripts, and he again was just not very happy with me.
Exactly. He told you your closing was lucky.
He did?
And he said that in front of everybody at practice, didn't he?
Well, it was at practice, so yeah, it was in front of everyone.
And that made you really angry, correct?
I was pretty upset.
In fact, you even told Mr. Brackman he was the worst coach in the state.
I did tell him that. I was angry at the time, I was a young teenager. I felt my emotions were high, and I was upset at him.
And because you were upset, you then left practice.
I did storm out to go. I did what I thought was just going to be a mild way to get back at him.
So you did leave practice.
As I just said, yes.
And you went out in the parking lot, didn't you?
I did, to do something I thought would be a small way to get back at him.
And when you were in the parking lot, Mr. Becker, you saw Mr. Brackman's car, didn't you?
I did, the white Porsche.
And you knew that Mr. Brackman loved that car.
Yes, and again, my intention was to do a small prank that would get back at him, nothing to permanently deface it. I would never do something like that.
Mr. Becker, I'm not asking what your intention was. I'm asking that you wrote on Mr. Brackman's car, Worst Attorney Award. And you did that, didn't you?
Well, I think my intention is important. I never was permanently trying to deface his car, but yes, I did write that, if that's what you're asking. But my intention was never to permanently deface it. I would never do something like that.
But Mr. Becker, because you accidentally defaced his car, Mr. Brackman yelled at you, didn't he?
Well, rightfully so. I mean, if I had known it was a permanent marker, I never would have done it. It was a terrible thing.
In fact, Mr. Brackman was so mad that he threw you off the mock trial team permanently. Isn't that correct?
He did kick me off the team, yes. Very unfortunate.
And that made you even madder than you'd already been, didn't
I
it?
was mad. After my conversation with my mom, I calmed down a great deal, though.
But Mr. Becker, after Mackenzie Brackman threw you off that team, you were even madder than you'd been earlier, weren't you?
I was pretty mad. And again, after my conversation with my mom, I calmed down a great deal.
Well, so after Mr. Brackman yelled at you and threw you off the team and you got angry, you went home, correct?
I did, and I had a great conversation with my mom, as I previously said.
And you told your mom that you were going to get back at Mr. Brackman if it was the last thing you ever did. Isn't that true?
So I feel that quote needs a little context. You know, that was about the peak of my anger right there. As any young teenager knows, sometimes, especially when you're talking to your mom, you can say things that sometimes you don't mean, or that's a person you can vent to. And I did, and I said that. And then, you know, later on, I realized that I needed to apologize. That's when I started feeling really guilty, and I started taking responsibility for it. And after that great conversation I had with my mom, where I calmed down a great deal after I said that, that's why I decided to apologize to him and offer to get a job over the summer to pay for the new paint on his car. And I really just wanted to apologize to him.
Objection, Your Honor, non-responsive. I asked a very simple question, and this witness has just gone on for over 30 seconds. All I'm looking for is a no.
Yeah, if I may respond, Your Honor, the witness did not go on for over 30 seconds with his response, but he was just elaborating on the question that he was asked. I don't believe he was doing anything that would call for an objection.
Ms. Ryan, any reply?
Yes, Your Honor. I asked if the witness told his mom that he was going to get back at Mr. Brackman if it was the last thing he ever did. He then went on a very lengthy explanation when all that he needed to do was confirm or deny if he said those things. I'm not asking him about his intention. I'm sure he can explain those further later. I'm just asking what he did.
Okay, so the court is going to sustain the objection in part. I don't know how long the time was that the answer took, but whether it took 30 seconds or not. But any explanation as to why he might have made that statement will be stricken and disregarded by the jury. And any other questions, Ms. Ryan?
Just, may I ask the question again, Your Honor, just to finish this up?
Yes, please. And we'll allow, okay, I see that there's time being kept there. So whenever you're ready, Ms. Ryan.
Yes, Your Honor, thank you. Mr. Becker, that night when you went home, you told your mom that you were going to get back at Mr. Brackman.
Your Honor, I'd like to object to the statement on the grounds of hearsay. The claim that he made was an out-of-court statement, and she's offering it for the truth of the matter asserted.
Your Honor, if I may.
Please.
This falls under Rule 801D2, a statement of a party opponent, as well as Rule 8033, a statement of a plan.
Ms. Glass, any reply?
No response, Your Honor. I just stand by my objection.
Okay, the objection's overruled as it would clearly be a statement by a party opponent. Ms. Ryan?
Mr. Becker, that night when you went home to your mom, you told your mom that you were going to get back at Mr. Brackman if it was the last thing you ever did, didn't you?
Beginning of the conversation, I did.
Thank you, Your Honor. No further questions.
Thank you. Any redirect by defense?
Yes, Your Honor, a brief one. May I proceed?
Yes, whenever you're ready.
Mr. Becker, did you feel that you needed the approval of Mr. Brackman for your skill in mock trial?
That's something I was always looking for.
For what reasoning did Taylor Perkins quit the mock trial team?
There was multiple reasons. It wasn't just because one of the reasons was because he knew that coach would have to put me back on the A team, but it's also because he didn't really want to be an attorney, which he was that year. We weren't in the same team, so we couldn't really talk to me, which was one of the biggest reasons why he was doing it. So at that point, there was really no reason for him to keep playing or keep participating.
Moving forward, did you express strong regret for your actions towards Mr. Brackman's car?
I did. I felt awful about it, which is why I tried to apologize to him. Again, offered to get a job to pay for a new car and offered to scrub the paint off.
Did you do anything besides try to apologize to Mr. Brackman in reaction to your dismissal from the team?
That's all I did. I just wanted to apologize.
Would you say that you were more sad or more angry about the situation with Mr. Brackman's car and your dismissal from the team?
Sad.
And finally, can you elaborate on your claim about wanting to get back at Mr. Brackman with your conversation with your mother?
Sure, of course. You know, I felt, again, it was a moment of anger for a teenager who had gone through an emotional time. And as many teenagers do, I was talking with my mom, someone I felt comfortable venting to. And in my initial anger, I said that. But then after me and her talked, I realized I needed to calm down. And that's when I realized that it was my fault and I felt guilty. And that's why I really wanted to apologize. It was a great conversation.
After that conversation with your mom, were you angered at all still?
No, I just felt guilty and wanted to apologize in any way possible.
No further questions, Your Honor.
Okay, thank you. Ms. Ryan, I do recognize that you're out of time, but is there any recross limited to the scope of redirect?
No, Your Honor. Thank you, though.
Okay, thank you, Mr. Becker, for your testimony here this morning. Are there any other defense witnesses?
No, Your Honor, the defense rests.
Okay, so that I believe concludes the evidentiary portion of our hearing here today. We will now start with closing arguments. Because the people have the burden of proof, they will have an opportunity to go first, and if they reserve any time to give any rebuttal, the people will be responsible for keeping track of their own time for the purpose of rebuttal time. Are the people ready with their closing statement?
Yes, Your Honor. I would like to conserve rebuttal time.
Okay, and as I indicated, you will be responsible for tracking that time, but whenever you're ready, Ms. Ryan.
All right, just one moment. I will get set up. He wanted revenge. He got it. Avery Becker needed revenge. He had vandalized his coach's car. He'd been thrown off the mock trial team. He had to raise the stakes because if there was no mock trial, he had to at least get even. So he put on a disguise and went to Mackenzie Brackman's house to trash it. But a struggle ensued and Mackenzie Brackman ended up dead. He wanted revenge. He got it. Today, the prosecution has charged Avery Becker with murder in the first degree and burglary in the second degree. Today, we had to prove to you that Avery Becker knowingly and intentionally entered unlawfully into Mackenzie Brackman's home, and that while he was there, Mackenzie Brackman died. And members of the jury, the prosecution did not have to prove today that Avery Becker went to Mackenzie Brackman's house with the intention of killing Mackenzie Brackman, only that while committing the crime of burglary, Mackenzie Brackman died. And the prosecution had to prove this to you beyond a reasonable doubt. Members of the jury, we have done exactly that today by showing you how the defendant wanted revenge and how he got it. It's actually quite simple. On March 6, 2020, Avery Becker had a score to settle. He was mad about being thrown off the mock trial team, mad that Mackenzie Brackman had never given him the credit that he deserved. He wanted to make Mackenzie Brackman feel just a little bit of the pain that he had felt and go and trash his house as payback. Members of the jury, you saw the text messages sent by Avery Becker to Alex Cifuentes, spelling out for you, word for word, his intent to trash Mackenzie Brackman's home. But you don't even just have to take the defendant's own words for it, because we know where Avery Becker was on March 6th. We know that Avery Becker was at Mackenzie Brackman's home. You heard today from Detective Markowitz how the defendant's phone connected to the cell phone tower covering Mackenzie Brackman's home. A cell phone tower the defendant's phone never should have connected to. A cell phone tower the defendant's phone connected to 3 separate times. Once is a coincidence, twice is an accident. 3 times is proof. We know where the defendant was. We know that the defendant is the one from the Ring videos, that his size and build match with that person's. We know that it was the defendant who was seen on camera at Mackenzie Brackman's home on March 6th. He wanted revenge. He got it. Today, the defense tried to tell you that the prosecution's case was simplistic, speculative, and superficial. But members of the jury, that's not what we've seen today. What we've seen is that it's actually the defense's case. that is superficial, simplistic, and lacking in many ways. We've seen that the prosecution has used hard evidence to prove the intent of Avery Becker, to prove that Avery Becker was at the crime scene and that Avery Becker committed these crimes. We ask you for a verdict of guilty. Thank you.
Thank you. Is the defense ready with their closing argument?
Yes, Your Honor.
Whenever you're ready, Ms. Liebman.
Thank you. May it please the court, Your Honor, members of the jury, opposing counsel. My name is Sophie Liebman. My co-counsels Eliza Bachner and Haley Glass, and I thank you for your time and consideration in this case. Now that you've heard the stories of both the prosecution and the defense, it should be clear that the prosecution's case is nothing more than a simplistic, superficial, and speculative story. At the beginning of this trial, the prosecution promised that they would provide you with evidence beyond a reasonable doubt that Avery Becker committed this crime, but that is simply not what the evidence here today has provided. The defense called 3 witnesses today that testified to the 3 failings of the prosecution: Professor Van Owen, Avery Becker, and Taylor Perkins. First, Professor Van Owen testified to the simplistic and superficial part of the prosecution's story, describing how the police went with the simplest and most convenient version of the story, rather than following up with another huge suspect, Blair Rollins. The prosecution mentioned revenge, and Blair Rollins has a motive for revenge that's been passed down through a generation. We heard evidence of this when we talked about Blair Rollins' father, who blamed Mackenzie Brackman for his imprisonment. Imprisoning one's father is a much more powerful motive than a teenage grudge, wouldn't you agree? The superficial part of the police investigation is revealed when we acknowledge the fact that Blair Rollins, a major suspect with a strong, vengeful motive, is now nowhere to be found due to lack of police investigation. Avery Becker's testimony reveals the speculation in the prosecution's investigation. His cell phone, which is a large piece in the prosecution's puzzle, went missing the day before the murder. In addition to the fact that Avery was nowhere near his phone, the information from the cell tower does not provide a definitive location for the cell phone itself. As Professor Van Owen elaborated on in his testimony and in Exhibit 20, there are a myriad number of ways that the information of the cell towers could be inaccurate. The police could have narrowed that information down, but as I said, the investigation was speculative and superficial. Taylor Perkins' testimony also demonstrates the superficial nature of the prosecution's case, as Taylor Perkins provided an alibi for the defendant. You also heard the prosecution's 3 witnesses: Detective Markowitz, Kyle Cusack, and Alex Cifuentes, who betray the prosecution's 3 failures. Detective Markowitz displayed simplicity and speculation through rampant police incompetence. The police not only lost several photos of blood droplets, but failed to get cell tower communication records or ring video records to back up what they claim proves the defendant guilty beyond a reasonable doubt. Markowitz also betrays this superficial case when we remember the prosecution's burden of reasonable doubt. But the detective failed to follow up on a major suspect in the case. Kyle Cusack also gives away the speculation in the prosecution's case in his own obvious bias against Professor Van Owen, and in his assumption that there was only one sequence of events that could have happened. A flowchart hardly upholds the prosecution's burden of reasonable doubt. Finally, the prosecution called Alex Cifuentes, who discussed the blatant jealousy of the defendant. Cifuentes gave us text messages allegedly between them and Avery, but showed the superficial part of the prosecution's story by failing to bring their phone to the police station, replacing their phone not long after, and not providing a timestamp in the messages. It is not the defendant's fault that the prosecution failed to properly investigate this case, instead pursuing a simplistic, superficial, and speculative version of the truth. And a teenager should not be condemned to life in prison when a potential murderer could go free. Therefore, members of the jury, Your Honor, the defense respectfully requests that you acquit Avery Becker, an innocent young man who should not lose his life and freedom due to the prosecution's failure to uphold their burden of proving reasonable doubt.
Thank you, Ms. Liebman. Rebuttal from the people.
Yes, Your Honor.
Whenever you're ready, Ms. Ryan.
members of the jury, Ms. Liebman just got up here and told you that the prosecution's case was simplistic, superficial, and speculative. But that's simply just not true. Today, we've seen that it is, in fact, the defense's case that is superficial, simplistic, and speculative. They asked you today to believe their witnesses. They asked you to believe Taylor Perkins, who got up in front of you today after he swore an oath at the beginning of trial to not add facts outside of his witness statement, after he signed his name to his witness statement, affirming that everything relevant was there. And he added extra information. He did not tell the truth, members of the jury. They're asking you to believe the defendant's only alibi in the world is Taylor Perkins. But we've seen that we just can't trust Taylor Perkins. On the other hand, the prosecution brought you Detective Markowitz, who showed you the exact route the defendant took from his house to the defendant's house. You saw the ring videos showing the defendant entering and fleeing from the house. Today, you've seen text messages, you've seen hard proof from the prosecution. We ask you for a verdict that aligns with the fact that the defendant wanted revenge, a verdict of guilty. Thank you.
Thank you, Ms. Rain. And that concludes our testimony and arguments here today, and concludes the mock trial